His ex-wife is bonkers. She was all over him all the time. Send me money, send me money, send me money.
Yesterday, it was just that.
How can I send you money when I don't have a job?
She said her account was in the negative, so I transferred her a little bit of money to get her out of the negative. That, I mean, my alimony and stuff basically pays for where they live. So.
What can you tell me about her?
Didn't need a ton, but I mean, she was always calling to borrow money, and she can get a bit violent when she drinks.
How long would you say the alcoholism has been a part of her life?
Because I was supposed to have my son today.
Okay.
I mean, it's always been a part of her life.
Usually calls to make sure, hey, are you sure you're getting worse today? Because I've had job interviews.
She did it to me a lot, where she hit me and stuff like that.
Yeah. What do you mean hit though?
She punched me, I mean, more arms.
You technically have him more than she does. Is that where you're...
It's a not a good day.
That at whatever time it was that he was calling me, that he could wait for the few moments of me getting up to where out of school at 3 o'clock.
Any number of different reasons. So she kind of, I guess, maybe felt trapped or something.
Welcome back. Today we will be diving into a family court update. We've gone through the criminal court case, we've gone through the text messages recently, we've been catching up here, catching up there, but I have yet to do a family court update in general. And seeing how today her next court date is going to be in 4 days, less than a week, I think it's a good time now to see where we've been. However, a lot of things have been happening in the meantime, so I'm not going to cover every motion that's been submitted in the meantime. I'm still recovering from a back injury that will not go away for life now. But I still want to get into this, get caught up, and grab some popcorn for the hearing this week. The documents we're going to be going over are one, Sarah's motion that she submitted to the court. It's a long motion, I can't remember the title, but basically she's asking for all of Brian's money, yada, yada, yada. Then we're going to look at Brian's attorney's response to that mess of a motion. Then we're going to look at Sarah's response to Brian's response to Sarah's messed up motion. And then we're going to look at the new judge's decision on some of these motions and setting this next court date. And then a little shout out, these documents are courtesy of Tanika's 2 cents.
Good morning, my true crime lovelies. Hello, my true crime lovelies. Hello, my true crime lovelies. How are you? So, back to Sarah Boone.
Kind of. She gave me some other documents and then I asked for permission to screenshot other videos so I'm not constantly bugging her because unlike Miss Sarah Catherine Boone Paulsen...
Excuse me. You're eating my peach.
Tanika is an actual mother who has mothering to do. So make sure you go check out her channel after this video. Exactly, Linda. See, Linda's also a fan. Now to get through all the regular standard warnings. First of all, if you're new here, welcome to the world of long-form rant content where there is no structure nor goal other than me reacting to this and talking forever, and then we're finished when we finish. And the video takes however long it takes. So if you want to watch a video where someone just reads these documents all the way through, this is not the video for you. I claim no authority or expertise on this channel. These are just my opinions. You take what you take, you leave what you leave. But if you leave a like on the way out. That's just good home training. And with that said, let's dive right in. Sarah K. Boone, respondent. Motion to be heard during case management conference on Wednesday, March 26, 2025, and requested relief to be ordered by court from petitioner Brian C. Boone to pro se respondent Sarah K. Boone, per FLRP rule comes now pro se respondent Sarah K. Boone respectfully moves this honorable court to be heard and for requested relief as follows. 1. On June 15, 2018, the court entered a final judgment in Boone v. Boone, incorporating the marital settlement agreement and parenting plan dated May 3, 2018. 2. On February 25, 2020, respondent was incarcerated in Orange County Jail. No. You tried it. You just try to just say that sentence and walk away. Was incarcerated on charges of second-degree murder. Why is that the most important thing? Because everything you're about to ask for is going to be undone by that mere fact. You want to just squeak that in. I'm glad you actually do have a background in procedural history. This is new, so you're learning. That's good. But you trying to downplay and trying to soften things ultimately will make it look more guilty and stick out more in the end. You know, respondent was just casually incarcerated on February 25th, 2020. No big deal. I'm just going to be here for the rest of my life. 3. Following respondent's incarceration, petitioner ceased making court-ordered alimony and child support payments as stated in final judgment and failed to comply with both orders. I mean, you also failed to comply with the law as well when you murdered someone. So I think when the judge weighs those two in the balance, his failure to comply isn't that bad. 4. A case management conference on September 19th, 2020 addressed petitioner's noncompliance. The court verbally instructed petitioner to resume payments and adhere to the parenting plan. That's a lie! That's a lie! This is what I never understand about her is that, like, she will lie to people about things that are so easily fact-checkable. Do you think this new judge doesn't have the record? Doesn't have the actual minutes of every single case management hearing this entire case has ever had? Do you think she hasn't looked through it? But that's why she added the caveat of verbal, where the judge verbally instructed him because he didn't actually put it in any ruling. This was that status hearing we covered in a past letter where she wrote a follow-up letter just basically praising this man. Dear Judge Dean, I wanted to take a moment to thank you for allowing me to be in attendance during the case management meeting last Monday, 9/19. It has been such a long time since something good and real has happened to me since being incarcerated for ongoing 3 years almost. I thank you profusely for helping me, listening to me, and having an open heart and mind to see me as a human being, a mother also. Your invaluable time, empathy, and understanding are beyond appreciated. Thank you for seeing me. I am so impressed, and my sincerest gratitude cannot be fully expressed for your kindness and goodness. I look forward to any future meetings there may be, and am confident my hard work, determination, and efforts will not return to me void or fall on deaf ears. A victory indeed in my battles in preparation for the war on the horizon. I will not creep away as I continue to be brave and fight on. Thank you for giving me hope more than you know. It was an honor to meet you. Your honor. As sorrowful, yet always rejoicing. As poor, yet making many rich. As having nothing and possessing all things. 2 Corinthians 6:10. P.S. Thank you for seeing that crystal balls don't work at all, ever. Dust catchers. Sarah Boone. And the whole time, the judge had only made things temporary, not actually making a final ruling on anything whatsoever.
Oh my God! The whole time!
Please provide the permanent documents. Full custody and suspension of child support. Former husband's attorney was instructed to forward for your modifications, Your Honor, to temporary as requested. After I was able to explain my circumstances with having no money or family to hire an attorney once I am released.
Court sentences you to life in the Department of Corrections.
And my desperate need to be fully and completely reunited with my son ASAP.
Life in the Department of Corrections.
You graciously made the decision to make everything temporary. Thank you. Temporary means nothing is changing right now, that we're holding off and we're going to make final decisions after the modifying action, which was your criminal case.
Guilty of murder in the second degree.
He had the petition to stop paying. You had the petition, well, not petition, but you want to hold him in contempt. He said it's temporary and nothing's going to change. Now you're going to use that and warp it and say he verbally instructed you that you had to keep paying me and you didn't follow the judge's verbal orders, even though verbal orders are still recorded in the court minutes. But she just thinks that she can manipulate anything when she says verbal, just like she did when she was trying to get the police to care about her, saying George's family is going to kill me. I'm afraid for my life, this and that. And they're like, but no threats have been made against you. And she said, oh, yes, they have. Chelsea's like, do you have them documented? Are they on your phone? She's like, no, they're verbal. They were verbal.
You know, you have to do what you have to do to keep yourself safe. But at this point in time, no one has made a threat to you. No one has done anything.
I just haven't said anything to him yet.
Right. But we will obviously talk to them. And of course, we're going to instruct them that this is an ongoing investigation. You know.
I think my son.
Well, your son's with Brian and is going to stay with Brian. So we're going to cross that bridge when we get to it. I know you're fearful of it now. But nothing has happened to where you're in fear based off past history and what they think of you and how
They threaten me all the time.
Do you have proof or is it all verbal? Like what, in your phone?
No, it's verbal.
Okay.
It's verbal.
So it's he said versus she said.
Because of course it is. And every time she says it, the person that she talks to just happens to not be in the room and not be reachable at that moment in time, so she can spin whatever narrative she wants. She did the same thing when she was trying to get the boxes. She said, I was told this by this marshal who said I could have the boxes. Then the boxes don't fit.
We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them.
The hard copies of the discovery.
I do, and it was already provided to me, but the boxes unfortunately do not fit in the bag, where I did attempt numerous times and even had others try to help me put it in the bag.
Oh, really? So all the times they told you that the hard copies would not fit.
And I'm in the process of trying to figure out what needs to be purged. I also have my second family law case that I'm trying to be able to obtain those copies at my bunk as well.
I completely forgot about her other divorce case, about her not getting her alimony. So there's a pattern of warping and manipulating people's words in order to get what you want, and then it always falling flat. I don't know how she got around in her real life, because it doesn't seem like anytime she does this, it works. So I doubt it will work here. 5. Petitioner ignored the court's instructions, failed to facilitate visitation and communication, and continued non-compliance with financial obligations. 6. On April 12, 2022, petitioner filed a supplemental petition for modification of final judgment, seeking to terminate alimony, child support, and parental rights. 7. Despite no court ruling on this petition, petitioner continued making no payments and denied respondent virtual visitation and regular communication with the minor child.
That's a lie! That's a lie!
And so here we already see how she entangles the son with her finances so seamlessly and effortlessly. I mean, it's not really seamless or effortless. She puts in a lot of effort and it's very obvious. But anytime she wants to talk about, oh, you're denying me conversations with my son, visitations, and your financial obligations. I have nothing. I have no money, or my son, because if I sandwich it in between then it's okay. And it makes my financial arguments just as strong as my child arguments, which your child arguments are stronger. But even there, what we've learned in the last video when we've started to cover her tablet messages is that she is more abusive than we even thought was possible, with how many times she harasses the son and the father. And there's a difference between denying you visitation and not allowing you access to talk to your child, and your child not wanting to talk to you. Because what we see in these text messages is you harassing Brian to force him to talk to you. To Brian, Tell son to plug in phone. Goes directly to voicemail, and I've been trying to call all weekend, day and night. Going to call tonight. Waiting still also for your response to any of my now 60 messages. Please respond. That is the definition of harassment, and you take pride in it. But that does not mean that he is denying you visitation or access to your child. He's actually defending his child from a convicted murderer harassing his cell phone day and night. 8. On April 11th, 2023, respondent filed a motion for contempt regarding non-payment of alimony. 9. On April 18th, 2023, petitioner filed a motion for continuance, arguing a pending modification petition as well as respondent's incarceration constituted a change in circumstances. Exactly. And because her priorities are everywhere else and her arguments are non-concise and she's just trying to throw a lot of things against the wall and say, look how overwhelmingly abusive he is, you have to side with me, she misses that this is the whole point. He is submitting all of these motions arguing a change in circumstance, which is the number one or the biggest influencer in alimony decisions when you're trying to modify things, terminate it, or reduce it. Is there a change in circumstances? Because if there's no change in circumstances, then no, you're not going to reduce or terminate your alimony changes. You just have to live with it. You signed it, you're under it, Side note, side note, side note. I'm going to step on my soapbox real quick. Everyone who hears me who is about to get married or even married, get a prenup. Get a prenup, get a postnup, get all the nups you can, okay? There's no shame in a little postnup clarity. It is not too late. Everyone just has this misconception of what a prenup is. And it's just like you only get a prenup if you're going to marry a gold digger, and we're never going to get a divorce. We don't need a postnup. We don't need a prenup. All a prenup and a postnup are is saying we get to decide what happens to our money if we split. That's it. Sure, the traditional thing is, here's a prenup so you can't come after my money. But if you all want to equally split it down the middle, you can do that. You can say, no matter what, whoever gets richer, whoever gets poorer, if we break up, we split everything equally down the middle. Or 80-20, 60-40, however you want to do it. I keep my assets, you keep your assets, and we just cut ways that way, clean breaks. You get to decide that. If you don't have a prenup or a postnup, that means the government comes in and then you have to go through this process. And in the prenup, you can put caveats of incarceration makes all of this null and void, or whatever you want to say. I think in this case, in her alimony settlement, she was not supposed to get drunk around the kid, which we definitely know she broke multiple times. But it also seems like she used that to her advantage too, because Brian said she would call him sometimes to come get their son because she wanted to drink. Which on the surface, you're like, okay, maybe a parent's trying to be responsible. But if you're viewing it through Sarah's eyes, oh, you're saying that I can't get drunk around my son. That means you have to take him. Oh, are you really going to deny me? Are you really going to get me in trouble? You have to come take him. Again, this is all me speculating. That's 90% of this channel, but I'm probably right. Anyway, if they had a prenup, none of this would be happening right now. And then that's also a good test indicator. If someone is completely opposed, gets completely offended, no matter what, maybe that's not the person for you. Maybe they see a different future if y'all get separated. What is it? The stat is like 50%, nearly 50% divorce rate. So get you a prenup, love who you love, have a good long conversation about it, be nice to each other, come to different agreements, what have you. If you are the spouse that doesn't have money and you're marrying into money and you get a prenup and y'all are really in love and this isn't about this and this isn't about that, then just be upfront saying, if we are already coming into this with a wealth disparity, if we leave, I just want us to split it down the middle. And that could happen. Sorry, I'm done with this. You get it. You get what I mean. I'm gonna stand by it though. Get you a prenup. Also, divorce is expensive as I don't know what. If you get a prenup, you get to skip all of that. Now, what was I talking about? Oh, that's right. Change in circumstance. Because that's what this whole thing is. If there's a major change in circumstance, that is when things can get readdressed, reassessed, and what should happen in the future. Your change in circumstances is that you are incarcerated. I know you try to brush past it, but
we, the jury, find the defendant guilty of murder in the second degree.
And
Ms. Boone, court sentences you to life in the Department of Corrections.
So because of that, you changed the life of everyone around you. That's why this is happening. 10. On April 19th, 2023, the court granted petitioner's motion for continuance. 11. Petitioner's failure to pay court-ordered alimony has left respondent without the financial means to retain counsel or afford basic communication items, essential hygiene items, food to maintain blood sugar levels, medical bills, clothing, and other necessities needed in order to live appropriately while incarcerated at the DOC. Okay, and just because you call it a necessity does not mean it is a need. How do we know you don't need it to survive? Because you're alive. You've been alive this entire time. There is no legal obligation for him to ensure that you have those things. You have money put on your books here and there. You decide what to do with your own money. If you need these communication things, if you need personal hygiene products, if you need things to live appropriately, you need to use your money wisely. Spending $60 on the tablet to send harassing messages that you could have used to buy anything else that you needed, that's a you problem. And especially in civil court, no one is going to award you money based off of your preferences and the fact that you want some snacks to feel comfortable in jail. 12. On March 12, 2025, respondent received a court notice requiring her to appear before a case management conference on March 26, 2025. So that was the procedural background. I know I stopped a lot in there because normally you're just stating the facts to build up to the context of the actual arguments you want to make, but she shoved all of these opinion-based arguments in there that I just had to say a few things. Now we're going to move on to her actual talking points. 2. Sealing family court case. 1. Respondent's criminal case has received national and global media attention. As a result, this family law case is covered extensively on social media. 2. Respondent requests that court seal all files to protect minor child safety, mental well-being, and possible harassment. Now, you have the right to ask for it to be sealed, but don't even pretend that this is because you're trying to protect your son against from harassment. Because first and foremost, you're the one who harasses him more than pretty much anyone else. Second, 90% of the people who cover this case are on his side and are probably more likely to be protective if they ever did come in contact with him. But it's really because you're now getting more coverage. Because originally, you asked for this to be unsealed. 1. Remove non-public status online to view print my documents. If unable, please explain why. The non-public status makes it impossible to utilize any contents I need from the website, since no one will provide for me and cannot obtain anywhere else. So when it could benefit you, you didn't care about that. You didn't care about your son being harassed because this was still in the middle of all of this, in the middle of your criminal case. So everything else was already public and popular. You unsealing this brought more attention and allowed documents to be released, but now you want it sealed. No, now you want it sealed because it all backfired against you, and it only makes you look worse every time we learn something new. Exactly, Linda. See, she knows why it's public, and so do you. 3. Request for mediation. 1. Respondent previously agreed to mediation, which was initiated and granted by the court. 2. Respondent wrote letters to petitioner's attorney requesting information, scheduling dates, and explaining that she had a serious medical condition, cancer, and an impending criminal case, and was cooperative and adamant about scheduling. She received no response from petitioner's attorney.
That's a lie.
She is a true American, the way she likes to revise history so quickly, because that's not how any of that went down. You didn't reach out to his lawyer first. He reached out to you saying, we want to schedule mediation. Can you send us your best dates available? That's it. That's the simplest request ever that you could ask. It's trying to meet her where she's at. You tell me when you would like to meet for mediation. Do you think she responded with dates? Mr. Martell, I am in receipt of your letter requesting a date to be set for former husband's petition to modify, but have a few concerns and questions before doing so. First, I would like to make it known I have been diagnosed with cancer. As said in my previous letter, no one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from which you have proposed. That being said, my questions are as follows. Those weren't the concerns. 1. What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify? Please provide documentation so I can understand the practices, procedures, and protocol for this area of family law. 2. Please provide copies of all documents to be discussed. 3. Please send contact information, location, and credentials of the selected mediator, and how was she selected. 6. Is there going to be an agenda? 7. What if selected date has to be changed due to unforeseen complications or circumstances? Will I be penalized? Rescheduled? 8. Is the point of this mediation to try to force me into signing or agreeing to the only terms available presented by former husband? 9. What if I do not agree? As said, I do not know what date is best for me considering my current situations and now health complications. By answering and explaining further the aforementioned concerns and questions will most definitely assist in my decision making. Your expedited response is greatly appreciated, as well as providing all requested documents and information. Thank you in advance for your assistance, patience, and cooperation. Absolutely not. She went off on every tangent. I have cancer. Why is this even needed? She says now she wanted mediation, but in that first response, she was asking for the world, asking them to do everything to get her all of these things. And I cut that letter down a lot because who has time for all that? But even then, and the thing is, I don't have an issue with the questions per se. I have an issue with how they're asked and when they're asked, but the fact that she couldn't even provide dates. She said, could the dates be changed? Of course they can be changed if something comes up, but you not giving anything. You say, I need 1 through 7. All this takes time, right? Especially when you get slow mail and you're mad that you don't get all your things in the mail. You're requesting why you even need to schedule a mediation. That tells me you don't want it. But you say, I just want to understand this law. So, I need to know the reason why we need to schedule in order to provide a date to begin with. Then you're questioning what's going to be talked at the agenda. If you propose dates and then you asked all these questions, that would at least make this look better. But you're saying before I even attempt to believe and conceive of a date when I would want to have this mediation, you need to be my lapdog and get all of this. Why was this special mediator even chosen? Do I get to choose this and that? Are you going to force me to sign this and that? Just trying to be as difficult as possible. But now here she's just like, I was trying so hard. I wanted to reach out and I got no response. So she is saying she didn't get a response to what you just heard. Not bringing up the fact that she was offered all the power in the world to choose a date to begin with. 3. Petitioner told court that respondent was not participating in mediation, and court subsequently canceled mediation. 4. While respondent's health is still not stable, her criminal case is resolved, and respondent respectfully requests mediation be resumed. Mediation is extremely important to respondent. Mediation good. Me want mediation. Respondent want mediation. Goes full caveman at the end. It's just ridiculous, because this is what happens in her life constantly, and she blames everyone else for it. But the world bends over backwards to give her all the power in the world to make her own life easier. She chooses violence every time and wants to make everyone's life harder. And then when things backfire, I can't believe it. Why didn't my lawyers reach out to me to try to mediate something beforehand so this wouldn't have to happen? Why are they pulling out now just because I said I wanted to have them disbarred and that they're terrible people? Why on earth would you cancel the mediation when I just asked why did it have to happen to begin with? What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify? And then in the follow-up letter to the judge, she goes crazy being like, I have no idea why they didn't schedule it. Why is everyone against me? I am trying to alleviate any additional difficulties and am constantly coming up with solutions in everything to work with former husband to complete this process in a positive, fair, and accurate manner. How can this be done now the mediation has been dispensed? Both parties could have figured something out instead of just canceling completely. Former husband could have explained his intentions to help understand my circumstances better in being unable to choose a date for mediation 4 months in advance, on top of my cancer, on top of my trial. I simply asked for former husband and his attorney and yourself, Your Honor, to provide information so I could choose, even if the date had to be changed. I, the other party, was bypassed and ignored completely. This mediation is all I have to be rightfully heard and utilize my rights as a mother and human being. I attempted to be professional and correspond with everyone. I explained my situation and simply asked for some important documents to better prepare, as this would probably be my only opportunity to make myself count in all of this. My requests and questions were all an attempt to choose a date and schedule this much needed, very important mediation. I simply asked for paperwork to review, as I do not have any and am being accused by former husband of being difficult and uncooperative by not signing documents I've never seen or knew existed until being served with a summons notifying me of his means to take all I have left other than the marrow from my bones. Please understand, I never said no or that I was not going to schedule. I want to be at my best possible with all information for my review beforehand, as would former husband be and his attorney, but not myself, unless I request it. Why am I being penalized for wanting to be prepared? Why was no explanation or reason given or discussed for canceling the mediation? How would I have known any of this if not found and read by my son? Completely unfair and wrong. I am being penalized for doing everything I am supposed to be doing, and for my attempts to show my heartfelt desire and determination to be a part of this, to rightfully be the other party. And now she wants to act like no one included her in any of this. If she had proposed any dates whatsoever, even if they rejected them, even if they added different ones, even if they proposed other ones, she would have been cooperating and participating. But she didn't, and now she's mad that it backfired. And so because of this, she lost her chance for mediation. Brian said, nope, we're done. Mediation would have been, okay, I'm not giving you $1,000 a month because that's insane, killer. but maybe I can do $100 to $200 a month, and then you just make do with that. Still, way more than she should ever get, but she probably would have had a better chance of winning that argument than trying to go what she's doing now and get tens of thousands of dollars she has no chance of recovering. And then will be mad and sad and pouty when she loses everything again in that single cell that she will spend the rest of her life in, when she could have been out in 8 to 10 years. She is one of the luckiest white women out there with the amount of opportunities and how much rope and leeway people give with her. And then she hangs herself every time and blames you. 4. Reconsideration of contempt continuance. 1. Petitioner's reliance on Rosenblum v. Rosenblum is misplaced. Non-compliance with court orders is enforceable unless financial incapacity is proven. 2. Under Department of Revenue v. Jackson, support obligations remain enforceable until legally modified. 3. Petitioner has failed to present any evidence of financial hardship during respondent's incarceration, rendering his non-compliance unjustified to date. 4. Petitioner's actions violate due process and obstruct respondents' access to justice. She does like to be dramatic. It absolutely does not. And the irony of you saying that him using Rosenblum v. Rosenblum is misplaced is that you using, Department of Revenue v. Jackson is actually misplaced. His case law actually works because Rosenblum v. Rosenblum involved a wife getting incarcerated and a husband trying to cut alimony because of said incarceration. Not just because of said incarceration, but the main argument was this is a substantial financial change. So sets the precedent for me to seek to terminate it or to modify it. So it actually does apply. Her case does not apply whatsoever. In Department of Revenue v. Jackson, it was the husband or the non-custodial father who went to prison, and he had to pay child support, not alimony. He was still supposed to pay child support, and he said, look, I don't have the money, I'm incarcerated, I shouldn't have to pay. And the judge said, you know what, fair, I'm gonna terminate it. Then that ruling was overturned, and they said, no, the fact that you are incarcerated or incarceration itself is not enough to eliminate that financial obligation. Because if so, then anyone in jail would just say, I can't pay child support, sorry, no. No. Child support and alimony are different because child support is like, that is a true obligation. That child is entitled to the life they would have lived had the family stayed together. So you need a real good excuse in order to terminate or to alleviate child support obligations. She's trying to conflate the two as saying child support and alimony, one and the same. No, they're not. Alimony is amendable, always. Modifiable. It is not a fixed thing. It is fluid. You need to have a good enough reason to seek modification, which you going to jail for the rest of your life is a good enough reason.
To life in the Department of Corrections.
And she likes using big claims like he's affecting my due process and access to justice. No, he's not, because again, this is civil court. First of all, due process refers to like the government, the state or commonwealth's obligation to make sure that you have due process and access to the court. It's not Brian's job to make sure you have access to the court. He's not legally bound to make sure you have any information from court whatsoever. Nor is he bound to fund your access to courts. It's unfortunate, yeah, for you, but it's not illegal, and it doesn't completely stop your access to the courts. How do we know? You submitted this motion. You've submitted letters. You harass the court all the time. You have access to the courts. You don't have all the resources you want or need, but that's a you thing. From the moment you laughed at George and made the decision to watch him die, a lot of things changed for you. And the other wild thing about that department case is because He was incarcerated and he was the payor, not the receiver, not the payee. You are in jail saying, just because I'm incarcerated, you're still obligated and I still have the right to receive. No. So that case is absolutely misplaced because you have different postures. It doesn't quite apply the same way whatsoever because the case was about his obligation, not about the obligation itself. And also in civil court, you're not entitled for a court-appointed lawyer. That's what you do in criminal court because criminal court deals with your actual rights and freedoms. Like, you are not free right now because you lost your criminal case. Civil court isn't affecting your actual freedom, your rights in that way. This is like a private thing. Y'all's marriage dissolved because you were a nightmare of a wife. And sure, maybe he wasn't a great husband. I don't really care. He didn't kill nobody. So, you know. Okay, a short one, but thank you, Linda. I didn't know how I was going to end this. 5. Enforcement of parenting plan and parental alienation relief. 1. Petitioner willingly denies respondent contact with minor child and excludes her from all decision-making in, about, and for his life. When respondent engages petitioner on decisions regarding minor child, petitioner lies incessantly, threatens to hang up, tells her to shut up, laughs at her, berates her, and gives her silent treatment, wasting invaluable minutes on the telephone.
Bro. Do you know I almost just gave a fuck?
2. Petitioner engages in parental alienation, referring to respondent as a killer.
Guilty of murder in the second degree.
And a murderer. And other emotionally distressing comments in the child's presence. You're a killer. That's why I'm not doing anything. Former husband said in front of son on phone. You're not important to anyone. Former husband, numerous dates. You are not priority. Former husband, numerous dates. Dad says you're annoying and beg all the time. Son told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. I lie to you because I can. Dad does all the time. Son, you make no difference in our lives. Former husband, numerous dates. That's okay with you and acceptable, Judge Dean? Is that what you are giving him permission for and to keep doing and in front of my son? Causing minor child to repeat these terms, causing psychological harm to both respondent and minor child. 3. Florida law, see Hunter v. Hunter, and Perez v. Perez, affirms that incarceration alone does not terminate parental rights. 4. Respondent requests the court enforce the existing parenting plan to the petitioner, establish a schedule for regular virtual contact, and engage in all forms of communication needed between respondent and minor child. Require petitioner to complete an extended co-parenting course on parental alienation in addition to the already completed online course taken pre-divorce. See, and it's stuff like that that really annoys me because it's just like the absolute audacity to say, not only am I going to ask for all of this, I'm going to ask for tens of thousands. I'm going to tell you that you're being a shit parent, that you're taking my son away from me, that you need to make sure that I have boom, 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 boom. Also, I'm just going to try to rub salt in the insulting wound by saying you need to take a parenting course so that you understand how to be a father and how to not alienate my child. I mean, I only killed someone. That doesn't mean I don't need to be in his life just as much as I always have been. He should be talking to me even more now that I'm not drunk all day and I finally want to talk to him and I blow up his phone all day, every day. You need to force him by court order to force my son to talk to me. But also, the next step is I want you to force my son legally to be nice to me, because when we talk, he is saying distressing things. He's calling me a killer and a murderer.
Guilty of murder in the second degree.
I mean, I only filmed myself doing it, and he's definitely seen the film, but that doesn't mean he should call me that. And when she writes stuff like that, I'm like, what goes on in your head where you think a judge who is aware of your criminal case in general, that video is viral, so whether the judge has seen it or not, I'm sure she's aware of it too, or knows that you filmed yourself killing a man, and now are shocked people are calling you a killer. But she says it as if it should be so obvious. Obviously, I'm his mother. You should never tell a child that his mother who killed someone is a murderer. That's abusive. So she wants to require him to have some mythical course that he had after they divorced. They divorced in 2018. So after 2018, I'm sure they both had to take a course, but she's just going to say he has to take it. She loves to do this. She did that with George of, you need to take the domestic violence class. You need to take the alcohol abuse class, even though she's an abusive alcoholic herself. She doesn't think she ever needs to take these classes, but everyone else needs to do that because she's doing everything right. You're doing everything wrong. You're being mean. This is unfair. This is not nice to me. She's basically like, well, I didn't kill you, so why would you treat me differently? And it's funny that you want to enforce the parenting plan now so situationally, because with the text messages that we covered, you got so angry when he, and it was funny, he threw it in your face because you like to throw it in people's faces all the time, of when you didn't get a visit with your son on Christmas. You said, why didn't you bring him to see me on Christmas? You told me when on the phone lying about everything when I was trying to check status of anything since returning from your vacation, that I was not permitted to see my son during any of the holidays, including Thanksgiving, Christmas, and New Year's, stating, quote, "It's my Christmas and holidays this year, Sarah." I'm still dumbfounded you are enforcing the parenting plan while I'm incarcerated. You've had him for all the holidays ever since I've been here. That was you being cruel and controlling and you throwing your weight around. There's a lot. And depriving me time with my son like you do with everything. Why? Beyond ridiculous. Why don't you enforce or abide by the alimony section of the agreement? So it's situational. You know, she doesn't want you to follow the rules. She wants you to follow her rules. So you get just as technical as she tries to get with you and say, well, it's my turn to have our son for the holidays. So no, he's not going to go see you. I'm not going to force him to leave all of his family, all of the good vibes, and go see you. Which, sidebar, can you imagine like saying, hi, my teenage son, 11, 12, 13-year-old, whichever it was. I know this is supposed to be one of the happiest days of the year, but we're going to go to a prison now where you're going to get emotionally guilted into feeling bad for her, and she's going to ask you to ask me for money. Or open this PS5 and then let's just have a good time. And parental alienation is real, but it also is dependent on the circumstances. Parental alienation is, oh, we had a divorce because someone was cheating, and now you tell the kid every time she's not around, she's a cheater, she's unfaithful, she's terrible, she only destroys people, you can't trust her, she's going to harm you, da-da-da-da-da-da-da. Things that are unfounded based off of the circumstances. Yes, there could be infidelity, but there's no reason for the child to view the parent differently because of that specific incident. And if the other parent is feeding this to the child, trying to keep them away from them, purposefully not allowing them to see the other parent without any justifiable reason, that is parental alienation. That is you trying to pit the child against the other parent. And it can go both ways, and normally it tries to go both ways, which is emotionally tormenting the child because whenever they're alone with one of the parents, they're trying to convince them the other parent is the actual villain, which is what she does all the time. She also just calls him Brian in her text messages to him, doesn't try to affirm his role as the father or give any respect there, just saying, I'm your mother and that's Brian. Those are more alienated tactics. And she wants to, and I keep repeating it, and I'm going to keep repeating it because she's going to keep repeating it, that she wants to force him to force these conversations. But when we went through the text messages in the last video, the text messages she sends to him are crazy. The amount of communication she demands from her child and then gets angry when he doesn't reciprocate just shows how much of a danger she actually is. And she doesn't get that every single one of those messages is going to bite her in the ass in this exact case. So I want to take a little detour and just look at the messages she sent her son in the video that we covered in volume 1 of the tablet messages, and see if Brian is the one who is in the wrong for not forcing him to talk to her. Oh, okay, this is her first message to her son. Hi, sweets. Thanks for setting up your account finally. I guess better late than never, huh? I'm excited to talk to you this way now too. It's strange to be messaging you, but another way to tell you how much I love you. I tried calling you 2 to 3 times so far today, but no answer. What are you doing? I hope your day is nice. Like you. Sometimes. Question mark? Go check the mailbox to see if your card came I sent. I don't want to hear Dad say you can't go check later at night, and I don't want it sitting in the box while you're gone. Don't open if it is there so you can when we eventually have our video visit. Do emojis work? Can you see them? Oh, okay. Talk to you later. Right back about card and emojis. Love you in the meantime. Nah. So I'm guessing all these random question marks are the alleged emojis. Why are you still so snarky to your son? Like, this is rude. Sent to son. Smile, love you. Hope your day is super. Just wanted you to know I'm thinking about you all the time, actually. Please tell Dad to take pictures. Talk to you later. Be safe, please. Love, 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 love you. To her son. Happy New Year, or just New Year. I'm praying you will help make it a happy New Year. I keep trying to call you on your phone, and still it goes directly to voice message. I really do not want to call Brian, as I have said in the past many times. I was hoping you would actually listen and care and make an effort just simply to have your phone on and charged so I can talk to you. Why? It's not like I'm asking you to grow a third arm or lasso the sun. Just answer your phone. I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom and to understand my feelings. Yes, I have feelings, and how much you crush them by not caring enough to simply plug in your phone. Would you make sure it were on if Addison called, or Mary, or anyone other than me? If you are choosing not to talk to me, I wish you'd just man up. Jesus Christ. You're telling your teenage son that you just need to man up and tell me so I can stop looking like the fool you are making me out to be by calling just to be yelled at, called names, or hung up on. If you have nothing to say to me or care enough to include me and share your life, just be honest and say so. You are my son. I am your mom. Forever. No matter what, where, when, why. No matter anything. You can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. I'm already going through so much, then to be disregarded and spat on by you is unspeakable, and for no reason. Do you delight in making me feel worse? Does it make your day knowing you make me cry and feel worthless to you? Who am I to you? Really ask yourself that. Punching bag? Daily joke? Unwanted friend? Yes. That's how you make me feel. Know that, son. I can't make you care. I can't make you love. It's your choice, yours only. New year, new start, new everything. Your choice. Don't forget about me. Love always. Who am I? Oh my gosh. To son, Sarah. Sunny day, Sunday, scripture. This is the day the Lord has made. Let us rejoice and be glad in it. Psalm 118:24. Be glad always. Every day is a precious and unrepeatable gift. You can't go back and change what you said or did or didn't do. Every day you have one chance to shine bright for him, yourself, and others, including your mom. Be a rainbow. Be nice. Love more. Smile and believe in the good. Unrepeatable. Make all your days count. Love you. Oh, 14 minutes later. Plug in your phone. I've been trying to call you on your phone the last couple of days, and it just rang and rang, then voicemail. Now it just goes directly to voicemail. Please make the effort to plug in and charge your phone and make sure you have with you. It's not nice to me to not be able to talk to you because it's not on, especially with all the time off you've had for the holidays and the long weekend now. 2. I've explained many reasons for not wanting to call Brian's phone. Remember, if your decision is for me to not be a part of your life and keep trying to talk to you, just say. Just say. Your response last time I asked was that you wanted me to be. I wouldn't know from the lack of effort and intention to make possible from you. What else can I do? Honesty and effort. Not asking much, but missing out on talking to you. My one and only son. Love, your one and only mother. Please plug in and charge your phone. Keep with you so we can talk, please. To your son. Trying to call you. Your phone goes directly to voicemail. Still trying to call. Why can't you make sure it's charged and on and with? Please know it is not me not trying to talk to you. Effort and love? To son. Trying to call again. I just tried calling yet again. Why can't you? Rather, why won't you make sure your phone is charged and with you to talk to me? For how many times I have asked you and Brian, I keep using my credits that cost 50 cents each to remind you. Please plug in, charge, have with. Love and effort? Day, Sunday, scripture. Whatever things are true, whatever things are noble, whatever things are just, whatever things are pure, whatever things are lovely, whatever things are of good report, if there is any virtue and if there is anything praiseworthy, meditate on these things. Philippians 4:8. You have so many things that are praiseworthy and positive to think of joyfully, most of all, Him, and also including me. I meditate on the good things and people I have right now, no matter where I am, and always focusing on the positive. You can too. See the rainbows in the storm, no matter how heavy and hard they are. See them and know they are coming. Meditate on the good which is everywhere. Love and effort. To son. I love you. I hope you're enjoying your day, my lovely darling. I'm thinking about your sweet face and how much I love you. Love you, love you. I'll keep trying to call. Miss talking to you and knowing how your life is going. Please don't ever think I'm not a part of it. I am, no matter what or where. I'm never going to give up being in it. And for you, no matter what or where. I love you for everlasting to everlasting. Always know that. Talk to you later. Heart, heart, heart. To son, I try calling you every night with no answer. Don't you know by now the evening time is when I am able to call you so you have your phone with you? I call every night. Every night. Tonight it rang and rang, then went to voicemail. Then voicemail directly when I called back. You don't want to talk to me? It makes no difference when it is, as it's the same thing on the weekends. Anytime I call you, please don't think I'm not trying. It's you who are not. I hope you answer sometime. I love you. To son. Test. Test. Love you. Sunny day. Sunday. Scripture. Quote, I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel. Maya Angelou. Oh, your Sunday scripture is Maya Angelou, the patron saint, Maya Angelou. Oh, I love it. Make sure others remember how good you make them feel with all the softness, understanding, love, and positivity you can give to everyone, including me. I want to remember good things from you, which there is an overabundance of, now and future. Make a difference. Be the difference. Take the extra minute or extra effort to remember that I remember too how you make me feel, your mom, along with everyone you come in contact with. Remember, I love you. Thank you for your goodness. How many times are you going to try to guilt this boy into loving you? It's not going to work. Effort and love?
Gretchen, stop trying to make
Effort and love?
It's not going to happen.
Who am I? Oh my gosh. And for context, we only covered 2 months of messages in that last video. Every message you see in this video was sent within the span of 2 months. She was incarcerated in jail for almost 5 years, harassing them daily. Exactly. Linda thinks that behavior is unacceptable because it is. Then she cites 2 more cases, again, points for you for adding case law. Those cases still don't apply here. She cited Hunter v. Hunter and Perez v. Perez. In Hunter, it looks like the father was in prison. In both these cases, it was the father that was in prison and the mother was trying to terminate rights. In Hunter, it was because the mother had a stepfather, or not a stepfather, but was married, and the stepfather wanted to adopt the children, but they couldn't adopt the children unless they terminated the parental rights. And originally they did, but then that got overturned, saying just because he was in prison doesn't mean that his rights should automatically be terminated. You have to prove that he was willfully not involved in trying not to support the child, yada, 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 or that he was harming the child in any way. And there was no evidence of that at that time. And then in Perez, the father was in prison and the mother wanted to terminate his rights because he had not supported or was involved in the child's life. But there wasn't enough evidence that he was willfully trying to abandon the child and terminating. So just because he's in prison and can't support the way you want them to doesn't mean you can automatically terminate his rights. So yes, she is correct where both of those cases do say that incarceration alone does not automatically terminate your rights. Linda is exactly right. There's context added here. Both of those cases were non-violent offenses. That you are a violent second-degree convicted murderer.
Guilty of murder in the second degree.
At that time, charged with second-degree depraved heart murder. There weren't really victims related to those other cases, or at least the reason they were in prison had nothing to do with the child. However, in this case, she killed George in a place that the child lived. He had a room upstairs, which she then tried to glorify in sentencing, saying he beat me in the sacredness of my child's bedroom.
For breaking or removing the locks from all of the doors and sometimes the knobs altogether, so I had nowhere to feel safe, including the sacred space of my son's room where he beat me bloody on his bed.
Meaning he lived in that house and you killed someone in there. That's a traumatic event. That child is a victim of her. She'll never see that, but he is. Brian's a victim too, but of like all kinds of abuse. Financial, emotional, physical when she was out of jail and they were married. But her son has a lot of passive trauma related to her. That's another reason why he probably needed to move. Anytime he drove past it or was in even the similar area of the apartment complex, I'm sure that memory came to mind. I'm sure he remembers exactly where George died. He's walked through that place so many times. And Sarah just acts like, oh, it's a new day. Who cares what happens in the past? That doesn't affect you at all. And I've said this before, but I don't know if she's ever asked how he's been coping specifically with George's death. She's asked, how are you doing? I hope everything's going well, but not, I don't know. She blamed George once, saying, like, does her kid have to have a counselor because he witnessed you hitting her, which it wasn't proven that was the reason. If he did have a counselor, that was the reason he had it for. What do you think he would need, knowing that his mom killed her boyfriend? And apparently they were engaged. So then you look at the cases and say, well, is she a threat to her child? Absolutely. Those other two cases, there was no evidence that they posed a threat to the child. She has a past of emotionally abusing this child, of neglecting this child, leaving him at school constantly, which prompted Brian to have to call her multiple times to see if she was going to pick him up because she was so neglectful. And has a dangerous pattern of physical behavior. As that boy gets older, if she were out of jail, I definitely think she would have got physical with him. I don't know that for sure. That's just me speculating. But I mean, she scratches anything that moves against her. So I don't think he would be absolved from that either. And also, you've had CPS involved and called to your place before in the past. That still knocks against you now. Oh. Huh. Whoa. I never thought about this before. Yeah, CPS was called to her place because she zipped her son in a suitcase, and it was a joke, and they took pictures, yada, yada, yada. The investigation said he wanted to be in there. Cool. I just thought of the fact that he probably has been thinking of the fact that she zipped him in a suitcase also, and what that felt like when he was in there, and seeing and thinking about what George must have gone through with her not letting him out. I wonder, I mean, he has to, I mean, like, when you're going through this, you're thinking of every scenario. I'm sure he's thought, what if she was mad at me at that time? What if she didn't let me out? I don't know. But that's just wild to think that not only does he have trauma associated to a place that was also a former residence of his, not the primary one, but he also lived there, and a murder occurring there, as well as him experiencing the method of the killing. That would, F someone up for life. Honestly, that's crazy. So yeah, you pose a threat and a danger to him on so many levels, and you don't care. Could not even think about that twice. He should love you no matter what. And you're really complaining to the judge, saying the husband calls you names, hangs up on you, wastes valuable time by giving you the silent treatment. Do you think the judge is going to say, okay, now, Brian, do not give her the silent treatment. That's very mean of you. Bad Brian. How dare you call this convicted killer a murderer? And the thing about defamation, which is, basically what she's insinuating of, you are spreading lies and you are poisoning our child, is truth is the ultimate defense. He is not misstating any facts to your child. But whatever, I think I've exhausted this point. Moving on. 6. Enforcement of alimony obligation. 1. The final judgment mandates petitioner pay $1,000 per month for 84 months to respondent. 2. Petitioner has failed to pay since February 25th, 2020, resulting in $61,000 in arrears. $61,000? Good grief. Oh my gosh. I knew she was asking for a lot of back pay. $61,000 is outrageous. To think that you, as a convicted inmate, felon, all of it, because this is now. We're now, right? Like, the text messages we've been covering were in the past, pre-conviction. This is post-conviction. and you think that you are entitled to $61,000. Could you imagine any family, parents, divorcees out there asking your spouse, if you have a child, who is a single parent at this point, asking for $61,000 from them to take away from your teenage child? Crazy. Okay, sorry. I have to keep going, but I was floored. 3. Under Florida law, compliance with alimony obligations is required unless a party demonstrates financial hardship. See Tyndall v. Tyndall, ba-da-da-da, Lamb v. Lamb, ba-da-da-da. Petitioner has not presented any evidence of financial hardship to the court during respondent's incarceration. 4. Respondent requests the court enforce the alimony order and compel petitioner to fulfill obligations, reducing alimony arrearages by any funds petitioner contributed to respondent during this time frame of her incarceration. 5. Respondent requests court to enforce petitioner to provide a current financial affidavit and bank statements confirming income since respondent's incarceration, February 25th, 2020, to the present date. And so the abuse and humiliation continues with trying to force him to show you his past bank statements in order to, I guess, prove that he doesn't have the finances to pay you what you're asking to pay for, which she knows he's been unemployed for a while. I don't know why or how he became unemployed. Unfortunately, I think you're a reason, or things that had to happen because of what you've done. And you know this. So that's why you're saying he hasn't presented any evidence to the court, which is what he's always planned on doing in this process in modifying this action. Like, that's the whole point of this, is he's going to show proof. But you are saying because he hasn't shown proof, that means he still has to pay. But you know he was unemployed, so you know that they're going to find that out. So why would you bring that up if you know he has some grounds for saying he has monetary issues? But all of this is about control, right? She wants to be able to force actions because everyone else gets to dictate her actions. She thinks she should be able to dictate other people's actions, and it's not going to work. You are not going to get him to get this affidavit swearing, here are all my finances, so please just let me not have to pay her. But don't worry, Brian, she says, it's okay, just reduce any money he's paid me so far from the $61,000. So I'm not trying to get the whole $61,000 because I'm rational. You can subtract it by the hundreds that you gave me, or actually the thousands that he's given you over the years, which she would say makes her reasonable and makes her request not absolutely absurd, just completely ludicrous. This idea that you are owed $61,000 for killing a man and sitting your ass in prison on taxpayer dime. No. And she brings up 2 more cases here that don't apply to her. Which is wild because they apply to her argument, just not the ones she made here. The 2 cases prior she used talked about alimony and incarceration, and just because incarceration is involved doesn't mean alimony is just eliminated. She is saying you are still obligated to pay alimony unless you demonstrate financial hardship. See Tyndall and Lamb. But in both of those, they dealt with you still had the obligation to pay until the court officially modifies it. So Tyndall, there was a divorce. He was citing her conduct, doesn't get into specifics, but just says, 1, she doesn't have the need for it anymore, and her outrageous conduct, is why I stopped paying. And at first the court was like, okay, cool. And then the appellate court's like, okay, not cool. But not based off of his reasons. It was you needed to go through the process and get the court to officially modify it. You didn't do that, so you're still on the hook for what you didn't pay in the meantime. And Lamb was similar and just said she didn't need it, so he just stopped doing it, and she just said, and the appellate court said the same thing of, you can't just stop, you have to have the court officially modify it. So that is an argument that she is making in here somewhere. It just doesn't tie to what she brought up. Nowhere does it say that they have to demonstrate that they don't have the finances to pay in order for the obligation to be modified. It was about the fact that you needed to do the modification first before not paying, which is the argument her lawyer would have made if she could have afforded one. Or if she was just nice to people, I don't know. But anyway, I keep getting sidetracked. Her lawyer would have made the argument that she's asserting he stopped paying February 25th, 2020. He didn't submit his first modification until years later. I don't know exactly when. So based off of Tyndall and Lamb, he is still... Paulina Plain says she has things to say and she has logic to drop, which is he would still be on the hook for the money he owed in between that time. That would be a stronger argument to walk away with something. Still wouldn't work because you can get that all retroactively relieved and taken care of, but that would be a little more appropriate with the cases she cited. Moving on. 7. Modification of child support. 1. Respondent requests the court eliminate future child support obligations, allowing petitioner to retain funds for the minor child's expenses. 2. Any funds held in the Florida Disbursement Unit should be returned to petitioner to be used for the minor child, and these funds uses are to be mutually agreed upon between petitioner and respondent how and for the proper support of minor child. I guess this is her trying to be gracious. I think this is her amended motion because she originally sent the motion before and asked for child support as well. The mother incarcerated in prison for murder also asked for child support, which was the $100 a month on top of the $1,000. And so she wants $61,000 in alimony, so she wants $6,100 in child support. But no, don't worry. She says, I want all of that given back to him. I don't even think he gave it to you, so I don't know what you mean by given back. But she still wants to have control in decision-making on how that $6,000 should be used. And you know she would hold on to it with a death grip. Every single dollar she would want accounted for, and she would use every little thing in order. No, it would just be a mess. Absolutely not. But whatever, this was her trying to clean that up, realizing, oh, I can't actually ask for child support. I'm going to be angelic and give that money back. 8. Property recovery. 1. Respondent lawfully owns personal property, including clothing, furniture, multi-generational heirlooms, antiques, jewelry, and also a 2011 Kia Sorento. 2. Petitioner willfully assumed control of these assets and agreed to safekeep and maintain them at no cost. After numerous requests from the respondent, petitioner has failed to return them to the respondent's family and friends. 3. Respondent has heard unverified claims that the vehicle was, quote, scrapped and items in a storage locker were sold at auction. 4. Respondent requests an accounting of personal property whereabouts, including vehicle and items in the storage unit. Now, this is the dumbest request out of all of them. Asking the court to force him to tell you where your personal property, where your items are. Items that are null and void in your life. You can never have access to those items again. But the biggest issue is you don't have proof of this. You are saying that, like, he willfully took control of your items and said that he would hold on to them for no cost. Of course, she has to sneak that in, because that's not going to detract from her $61,000. He said he'd do this for free. That's like you gave him a gift. Do you have it written down anywhere? Or is it just verbal? Like we said earlier, she loves it when it's just verbal because she can warp the other person's words to say whatever she needs them to say. But unless she has the jail video phone call where she made this agreement with him to take all of her things, to hold on to it, and to return it to her, then it means nothing. Because also, you can never reclaim these items. It's just stupid. She can't get the personal items back. This is just another control tactic. She wants to force him to run down and do all of these lists just so she has it. So let's just say she has it. Hey, your car was sold off. Which is, oh my gosh, I rolled my eyes when she said unverified claims. Then why are you bringing them up? What does the court care about unverified claims on anything? We want verified claims, verifiable evidence, hard fact agreements to prove that he is doing the things you are accusing him of doing. Otherwise, it just seems like he took on more of your burdens. You go to prison for killing someone, now he has to deal with all of the things in your apartment because you're screaming, they're family heirlooms, they're important, they're this, my car is so important, da 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 da, and guilting him to hold on to these things. And now you're going to force him to tell you about these things anytime you want. Why? Because if she got this one time, she would use this again and again and again to harass him. Well, I know I asked you about the location, about the car. Well, now I need to know where are my family jewels. Now I need to know where's my, I don't know, taxidermy dead dogs. These are my things. You have to tell me where they are anytime I ask. But yeah, if she actually has a written agreement or actually finds that phone call where they agreed to it, then she could actually say something, but it still wouldn't get passed because it's null and void. There is no actionable relief here. Moving on. 9. Extension of pretrial discovery deadlines. 1. Respondent's incarceration impairs her ability to prepare for trial. 2. Under Florida law, incarcerated individuals are entitled to a reasonable opportunity to participate in all legal proceedings. See Carter v. Carter. 3. Respondent requests an extension of pretrial discovery deadlines to allow sufficient time for preparation of her defense. 4. Respondent avidly and eagerly seeks appointment of counsel to prepare for her defense and simplify timeline. An extension will afford her the time needed to secure legal aid while waiting for expectation of pretrial discovery from petitioner. 10. Requested relief. Wherefore, pro se respondent respectfully requests this court: 1. Seal all family law cases in protection of the minor child. 2. Resume mediation proceedings as originally agreed upon by petitioner and respondent. 3. Reconsider the motion for contempt continuance to finalize monetary obligations by petitioner to respondent in hopes of aiding respondent in acquiring counsel to expedite the process. 4. Enforce the parenting plan to the petitioner, which includes respondent in all decision-making for minor child, and establish regular virtual visitation and all applicable communication rights. 5. Require petitioner to participate in an extended co-parenting course addressing all forms of parental alienation, as previously discussed. 6. Enforce petitioner's alimony obligations to respondent and order all payment of net arrearages after a compilation of financial affidavit and bank statements during respondent's incarceration have been reviewed. 7. Modify child support obligations as requested, especially the collaboration between petitioner and respondent. Respondent requests her inclusion in the decisions going forward regarding the use of these funds for the minor child. 8. Order the petitioner to inform respondent of all of her personal properties whereabouts as described above. 9. Extend pretrial discovery deadlines to ensure fair participation in proceedings by pro se respondent. 10. Grant any other relief this court deems just and proper. Respectfully submitted, Sarah K. Boone, pro se respondent. Yeah, I just wanted to let that play a little bit so that we can finish this document and move on to the next one. Let's break this whole thing down. So at first, she wants an extension of deadlines. I don't know why. I mean, like, the extension of discovery deadline throws me a bit. Like, it's your evidence. What else more do you need to discover? What else more can you discover? And normally when pro se inmates ask for an extension in time, it is, granted within reason. However, this has been going on for years. This started in 2022. And she's had multiple continuances, as she's mentioned in here. So you've had time. Now that you realize there's no more mediation and that it's actually getting real and you can't avoid this and you can't run around in circles anymore, now you realize you weren't actually working on this case. And yeah, I'm sure your criminal trial took your attention away from this. Well, by the phone records it didn't. How did you could have been working on your criminal trial instead of blowing up their phone every night. It wouldn't help you in either case regardless, but still. And she wants an extension in order to get legal aid. Like, if you haven't gotten it now, you're not going to get it. You also seem to think that money was the only issue. It is also just you in itself. You're going to need a lot of money to pay for a lawyer to swoop in at the last second, because then you're going to have the lawyer ask for a continuance of, oh, I just got on the case. I'm going to need more time to prepare. Judges know this. They're not dumb. Even though Sarah thinks everyone is dumb and stupider than her, they know what a stall tactic looks like. I think Just a Lazy Gamer did a video where he talked about how she reached out to 24 lawyers or legal agencies trying to get legal aid, and they all said no. No amount of an extension is going to get you those resources. And then at the end of that, I don't like, she's like, I need an extension to get a lawyer in expectation of pretrial discovery from petitioner. So she's saying, I want an extension on me providing discovery, but in that meantime, I want to be able to get a lawyer. And then once I get that lawyer, the petitioner should have already sent me their discovery while I'm still working on my extension. Does she not know extensions go both ways? Like, if you get time extended, he also gets time extended if he wants to update his discovery or anything. But no, of course you think it's... Exactly, Linda. Let's move on. So then she asks for what is the relief that she's requesting. One, she wants to seal the case. That'll probably happen. Maybe it didn't. Who cares? It doesn't really change anything at this point since you're about to have the trial and there's no takes backsies. But go for it. 2 wants to resume the mediation proceedings as originally agreed upon. Unfortunately, Sweets, there was nothing officially agreed upon because you wanted to send a snarky-ass letter as a response in order to stall things even more. So mediation is off the table. 3, reconsider motion for contempt continuance to finalize monetary obligations in hopes of aiding respondent in acquiring counsel to expedite the process. See, now this is a stalling tactic disguised as a plea for help. You're saying, I have to have this money, please reconsider the contempt continuance. Hold him responsible, force him to pay me money so I can get legal help. This is all just to get legal help so I can expedite the process further, failing to admit that this would only elongate the process. If the judge made that order, Brian would have a timeline in which to pay it. You wouldn't be getting the money the next day. Then whenever you acquire enough money, and then you'll be able to open a new bank account, then you have to get everything set up there, then you have to find new legal services, then you have to get in contact with them, then you have to have visitations, and you have to have money for this and that, We're in 2026 at this point. So no, this would not expedite the process. This would elongate it exponentially so. Then she goes to 4, enforce parenting plan, which includes respondent in all decision making regarding minor child. Absolutely not. It is impossible for you to be involved in all decision making. And here's another thing. She likes to make big, bold, blanket claims when that's not really what she means. She would argue, I just want to be involved in any of the big, major, life-altering decisions. But you're not saying that. You're saying you want to be involved in all decisions. Does that mean they have to call you to decide what he's going to get at the grocery store, what they're going to get for dinner, what movie they can go watch, what sports game they can go, where they can go on vacation? Every single decision for the child? Absolutely not. But we all know this already. It's only for control. The root of every single one of these requests are not for relief, it's for control. Brian's requests, and we'll see the contrast, are actually for relief from an abuser that is just draining all the resources their household has. And she wants you to establish regular virtual visitations. You have to require him to force my son to talk to me. And all applicable communication rights. Another big nebulous blanket term that just means I want him to answer my phone calls, answer my texts, answer my telegrams, and if I find a pigeon that's just hiding in the courtyard that I take back to my single cell and then teach how to be a carrier pigeon, send it to him, I expect a response within the same week. 5, just to add an insult, extend co-parenting course addressing all forms of parental alienation. There's no proof this mythic course exists. She just wants you to punish him and to tell him he is being a bad father. You know, the one who didn't murder someone and absolutely ruin their child's life. It would hold more water if she said that we both could take this parenting class so we can move forward with the same understanding. But it's always punish them. And then she keeps wondering why she is the one who gets punished instead. 6, enforcement of alimony, obligations to respondent, and payment. This made me die out laughing. When she said, I want payment of net arrearages, she said, I want it after taxes, okay? I want my cash money net after taxes, after we've had a compilation of your bank statements has been reviewed. Reviewed by who? By the court? By you? And then you have to tell the court, and then the court order the specific amount. See, it's just a never-ending request with her. I can't say that word. I like choke on it every time. Request. Anyway, I also found out that yeah, she wants it net, but in Florida, if you had a divorce before December of 2018, which their divorce was in June of 2018, before, then your alimony can be taxed and the alimony can be written off. But January 2019 and on, it's not taxable to the recipient or a tax deduction to the payer. So even if she did get the $61,000 net, she'd be moved to a higher tax bracket than she was and would have to pay taxes on all of it. And then 7, she wants to modify child support. The thing is, you weren't getting paid child support. There's nothing to modify. She's saying that it was held in this disbursement fund. I haven't looked into it. If the money has been going in there, whoopee, you get that $6,100. But no, at that point, I would just give her the $6,100 rather than her tell me that she gets to have control over what happens with every single penny of that $6,100. She's going to say, I want a Snickers on Sundays. I want him to call me on Thursdays. I want you to put $5,000 on his tablet so he can answer every single one of my messages, etc., etc., etc. But the answer is no. You do not get to be in charge of how Brian uses his money for the child. If you had any money of your own, then yeah, absolutely. But you don't. And it's all going to be made null and void because when the judge sides with Brian, it's going to be retroactively taken care of, so that $6,100 would have never gone to you, in theory or in reality. Number 8, order him to tell you where your personal property is. dead on arrival, no chance. The judge may ask Brian, like, just literally in court saying, do you know where her things are? And he could say no, and she'd be like, okay, moving on. Number 9, extend pretrial discovery deadlines to ensure her participation. Hey, fun fact, you're participating right now. There hasn't been a moment where you haven't participated. There has been no hearings without you, to my understanding. There have been no backdoor deals, no this, no that. He got the order for mediation canceled because you wouldn't cooperate. You thought that this whole back and forth, we have to go round and round and round and I tell you when you get off this merry-go-round. Brian's lawyer said, no, this is not a circus, but I will put on a show if I must. And I think this is a great transition point to now officially move on to Brian's response from his attorney, where he absolutely lays into her. Finally, Brian has been able to respond, and this is kind of like everything that's been pent up. He paid his lawyer. His lawyer earned his check on this one. Whatever he charged to submit this motion, congratulations, you earned it. Petitioner's response in opposition to former wife's pro se motion seeking enforcement of alimony, child support, sanctions, and attorney's fees. Comes now petitioner Brian Boone, former husband, by and through undersigned counsel, hereby files his response in opposition to former wife's pro se motion seeking enforcement of alimony, child support, sanctions, and attorney's fees. In support of this response, petitioner states as follows. 1. The parties' marriage was dissolved by final judgment on June 15, 2018, incorporating a marital settlement agreement and parenting plan. Under that judgment, former husband was ordered to pay former wife $1,000 per month in alimony for 84 months and $100 per month in child support. 2. These obligations were predicated on the expectation that former wife would care for the minor child during her time sharing and have financial needs outside of the marriage. 3. On February 25, 2020, former wife was arrested and has remained continuously incarcerated since that date. 4. She has exercised no overnight time sharing since her incarceration began. In fact, due to her imprisonment, former wife has been completely unable to care for, support, or spend any overnight time sharing with the child for over 5 years. 5. On October 25th, 2024, former wife was found guilty murder.
We, the jury, find the defendant guilty of murder in the second degree.
And on December 2nd, 2024, she was sentenced to life in prison.
Ms. Boone, court sentences you to life in the Department of Corrections.
6. Since 2020, the former husband has provided the child with a stable home, covering all expenses for food, clothing, medical care, education, and other needs without any contribution, financial or otherwise, from the former wife. Which has always been the craziest part for me since the beginning. She knows she's in prison for murder. She knows she can't take care of her son. So in her mind, she's like, you can't even hold that against me because you know if I wasn't incarcerated, of course I would take care of him. Whatever. Fine. I can see her justifying not taking the responsibility of actually taking care of him because she can't. However, she knows that, and she knows he has taken the son solely 24 hours a day, 7 days a week, without any other assistance whatsoever. Well, I think he's being assisted by his family, but in terms of partners. And yet she feels so comfortable to ask for $61,000, knowing she's taking that away from him. My belief is because she was only living off of alimony anyway, and so she was using that alimony to pay for her apartment, take care of herself, beg for more money than that, and take care of their son when he was over there. So in her mind, she's like, well, we've always been just living off of your budget anyway. I mean, I didn't work during the marriage, and I didn't work after the marriage either. Which isn't true. She had little jobs here and there. For some reason, she could never keep a job. And most of it was in reception type work, which then she tried to amplify her positioning, which, anyway.
Sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
But whatever. She could have gotten a side job to add to that, never did. So in her mind, I'm still a part of your budget because you are taking care of both of us. Just because I'm in jail doesn't mean you still don't need to take care of me and my son. I mean, I called you all the time anyway to take care of him, so you pretty much had him 24/7. I could totally see her in her warped mind and perspective justifying it that way while still seeing herself as good. So she thinks, I'm still doing my job because I'm harassing him and you 24/7. That's me showing you if I were out, of course I would be taking care of you. I'm doing my job. I'm showing you I'm trying to be as involved in your life as possible, and you need to do the same for me. Not recognizing on the reverse, they have a murderer calling their house every night. That is beyond emotionally taxing and monetarily taxing. Every time they talk to her, they're wasting more money to be yelled at and someone begging for more money. But yeah, she hasn't thought twice about that, only can think about herself. Also, I love the petty fact that the lawyer is calling her former wife, because that is all that she has done for the most random undercutty reason, is to primarily prefer to Brian as former husband, and husband's always in quotation marks for some unknown reason. Judge Michael Dean, in all my attempts, 16 plus, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active abuse from former husband, Brian C. Boone, from former husband, from former husband, 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 how I am and have been and will be treated by former husband Brian C. Boone is unfair, malicious, and wrong, and should not be in any way allowed to continue. Stop. Please see, please listen, please help. Former husband. And that's all from one letter. And she took the effort to put quotes around each husband. Just because she's trying to devalue his role and thinks that's another little jab, even though it means nothing. However, he's just letting out all the pent-up things and meeting her where she's at and saying, we're using this petty language, so let's use this petty language. Former wife. 7. The former husband's day-to-day life became that of a single parent. He ensured the child's emotional and physical well-being, while former wife, through her own actions, rendered herself unavailable to fulfill any parental role. 8. Despite her ongoing incarceration, the former wife, acting pro se from prison, now moves to enforce the original support orders, to hold former husband in contempt, sanction him for non-payment, and to recover attorney's fees. 9. It is undisputed that the former wife has had zero overnight time sharing with the minor child since her incarceration in February 2020. By being incarcerated, she removed herself from the child's life, physically and parentally. 10. Florida law provides that a parent's lengthy incarceration, especially for a serious felony, is so contrary to the child's welfare that it can justify even termination of parental rights. See MSB v. RB. 11. The former wife has now been convicted of murder.
Guilty of murder in the second degree.
a heinous intentional act, ensuring that she will remain in prison for the entirety of the child's upbringing.
To life in the Department of Corrections.
12. Florida's public policy and laws strongly condemn violent criminal behavior, and a parent who is incarcerated for such misconduct cannot simultaneously fulfill the obligations or enjoy the benefits of an active parent. And there it is. I am glad he used specifically the words benefits, because she hasn't realized that all of these things she's demanding have been benefits. Everything she's demanded, this is his money. You are getting the benefits of his money because you were once married to him. You are getting the benefits of child support because you are an active parent and the child lives with you. If the child never lived with you and he had full sole custody from the start, and you just came in to drop by and visit here and there, you wouldn't be getting child support because you're not supporting the child. She thinks that she deserves it by virtue of being a mother. That's why she thinks she's entitled to Valentine's Day cards, birthday cards, Mother's Day cards. All these things she just expects and are floored when they don't happen for her. I mean, how many times has she thrown a fit over not getting these little cards? 9. Have former husband Brian C. Boone explain why he lies about sending anything for my son. A. February 14th, 2023, Valentine's Day card. Former husband collaborated with my 12-year-old son to lie to me about making me a card. Both said they went to craft store and bought supplies. My gift to son. Had son sit down Sunday afternoon, quote, and make, then mailed the completed card the next day. I was told my son wrote me a letter and drew something nice for me. I was really going to like it. It was all a lie. They never went or did any of it. What an awful, unnecessary lie. For no reason. Nonetheless, former husband had my son part of the awful lie. How disgusting and hurtful. No card ever. B. May 4... I'm losing my voice. B. May 14th, 2023. Mother's Day card. Former husband has told me 3 times now my son has mailed my created card. Nothing has come. Another despicable lie. Why? So hurtful, and son included. That are benefits. People who are actually nice people go their whole life and don't get Valentine's Day cards or Mother's Day cards or this or that, because that is not what's important to them. What's important to them is their kid. Even Linda agrees, because she's also a single parent. Puts her child first. She makes sure that the little engine that could is always taken care of, always has what he needs, and Brian has been doing the same thing. Does she care that he's basically been a single parent? No. Does she ever acknowledge that? No. It's an expectation. She has had 0 parenting role besides being a harasser and your child's first bully. Because at least if there are any bullies at schools, they don't have his phone number and are not blowing his house phone up at all hours of the night. So he does get some reprieve from them. She gives them none. She basically believes she should be able to move right back into their life, even though she can't leave, just functionally. I'm mom, I'm back here. I know I had a boyfriend, but he's dead. So we're just going to forget about that little saga, and we're just a big family again. And we're back under Brian's care and support. So why are you not caring and supporting for me as though I lived next door? And I think in her first time submitting her motion, she also put in there that she was seeking attorney's fees, which is outrageous. It's just like in her sentencing manifesto where and she cut it because Owens wouldn't let her say this in open court, but she was demanding where is her $15,000 for representing herself. Hatred for all those who did not include me to receive my $15,000 share I worked for when Judge Kranick forced me to be my own attorney, to represent myself as pro se.
Don't laugh. You can't laugh.
Bon appetit.
I actually and finally got my own discovery. Almost 5 years later, filed motions all prior should have done, making them the most expensive motions ever at over $46,000 between 3 prior attorneys. She believes she deserves $15,000. She believes she's entitled to have attorney's fees. In this case, it's so she can go get an attorney. But she doesn't have rates, money, nothing. So she just wants a random lump sum. And she's just going to tell the court that this is going to be used for attorney's fees, even though you can't prove that, especially since you have no lawyer and no one wants to work with you. Also, now that you're public and everyone has seen your behaviors, why on earth? Because she's also asking for a free attorney when she's been reaching out to other people. Why would you think anyone, one, would work with you, two, would work with you for free? When you had your criminal court case and it was publicized and everyone was watching it, and it could be like, oh, look, here, take this big advantage of coming to her legal aid. Okay, is it here? Is it? Oh, it's here. No. Oh, no. Inmate seeks attorney. Looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently, overcome all circumstances. And you can put yourself out there like Owens did. Everyone knows him. He might be one of the most infamous lawyers in Florida right now just because of his involvement. So she thinks she can still throw that, I'm a high profile figure, you all should be jumping to represent me because this could help you in your career. Everyone sees how you treat people, and you treat people like shit. If you were a nice person and people genuinely thought you were a victim, they would probably want to help you. Someone out there would probably want to help you. So if you ever wonder why all of your resources seem to disappear, maybe do some introspection. Maybe think, every time I'm given grace, given a new opportunity, a new resource, a new person who puts themselves out there for me to get me what I want, what I need, maybe I should respect that relationship rather than continually abusing that resource. And then when they finally leave, when they finally cut them off, or when she finally kills them, now she's like, oh, shucks. And that was the little engine that could, which means we're going to move on now. 13. From the moment of former wife's incarceration, the former husband had no choice but to step into the breach. He has provided the minor child with a loving, safe, and stable home without any assistance, financial or otherwise, from the former wife. 14. Equity should not punish the parent who stayed and fulfilled his responsibilities while rewarding the parent who abdicated hers. 15. The former wife's motion, however, seeks to do just that. She asks this court to compel the former husband to pay tens of thousands of dollars to her, despite her inability to contribute to the child's care in any way. The court should reject this request as it upends the purpose of child support and alimony under Florida law. And there it is. Because she lives her life off of stereotypes, especially stereotypes about women, she believes that child support means mom support. And even if I'm incarcerated, by virtue of having a child, you are supposed to support me. Absolutely not. But that was basically the opening. That alone would have been enough to beat her contempt order and any arguments that she brought up there. Well, she didn't really bring them up, but what she attempted to have done. And the rest of this is he's going to step by step address every single one of her outrageous claims, even though what we've already heard is more than enough already. And that's why he brought up the child support and the attorney's fees, despite in the one that we went over, she said, give the child support back, which is different than what she originally stated, to my understanding. And she didn't even mention attorney's fees in that last one. But Brian's lawyer still needs to respond to every one of those because nothing has been ruled on. So there exists a possibility where the judge rejects her withdrawal because she submitted the motion, then she submitted a withdrawal, then she resubmitted this one. So, I mean, the judge wouldn't, but there does exist a reality where the judge says, no, I reject your withdrawal and we're going to go off the first motion. And if the lawyer hadn't responded to everything in the first motion and only focused on what was in the second motion, then there would just be no record of those arguments. So moving on to the next part. Alimony arrearages claim. 16. Florida law is clear that alimony is awarded based on a recipient's need and the payer's ability to pay, and an award of alimony is not appropriate when there is no need for support by the requesting spouse. See Taylor v. Taylor, 17. Here, the former wife has no legitimate financial need for alimony at this time. By virtue of her incarceration, the state of Florida and its taxpayers is providing for her basic living needs, including shelter, food, and medical care. She does not pay rent, utilities, groceries, or transportation costs while in prison. 18. In other words, the primary expense alimony is designed to cover for a dependent spouse have been assumed by the government during her incarceration. Any incidental personal expenses she might have, commissary items, etc., are minimal in comparison to normal living expenses and are not the responsibility of the former husband. 19. The former wife's imprisonment is an involuntary lifestyle change for the family, but it was voluntary on her part in the sense that it resulted from her intentional criminal act. You better read her. I love it. I love that he's using all of these words, her intentional act. After how many times did she say intentional spiel?
But not intentional. My intention was not to leave him in there. My intention was not to leave him in there. I didn't do it intentionally. That was not my intention. But my intention was not for this to happen. It was not intentional. It was not intentional. Not intentional. I didn't intentionally go to bed because this was not in any way, shape, or form. Hand on the Bible, intentional. Not absolutely what happened. Intentionally. I didn't intentionally mean for this to happen. So you guys think that I intentionally didn't do it. That I intentionally did not do. Not intentionally. Not intentionally. Not intentionally kill him. I didn't do that intentionally. I did not intentionally do this. But my intent was not for that to happen. But you think that I did that intentionally. You think that I did that intentionally and not intentionally to leave him there. Or intentional. In no way, shape, or form was this intentional. Because now you all think that I had even more, in quotes, intent to do what I did then, which was not intentional. I'm being accused of something that was not intentional. I'm not admitting anything about being intentional and I killed George. Not my intent. It was not intentional. I promise you. it was not intentional, which I swore in my son's life was not intentional. That was not my intent. That's my intention. What, that it wasn't intentional? Yes, that it was not intentional. Not intentionally. We understand that.
She's still dead. I didn't do it.
Intentionally. Not intentional.
Okay.
This was not my intention.
You were trying to figure out what's going on. We're still trying to figure out what's going on.
Unintentionally.
I lied to the police. Basically everyone, because I was extremely fearful of being arrested. I made the first attempt of me calling 911 by telling them what happened, and I thought they were going to help me, but instead I was arrested for calling 911.
So you made the decision to lie?
I did.
Just a mess. But yeah, great points. This was an involuntary life change. So because she did what she wanted to do and killed someone, his whole life has changed, and she still expects him to do more and more and more for her, while providing absolutely nothing in return. That's the worst part about it. She has absolutely nothing that she can provide for them and doesn't even attempt to. But moving forward, I might not make as many comments on this one because he actually knows what he's doing. So I'm just going to let him pop off. 20. Florida courts consider such self-inflicted changes when evaluating support. For example, in the child support context, our courts hold that, quote, an individual's actions that lead to incarceration are voluntary and do not automatically justify avoidance of support obligations. 21. The former wife's need for alimony has effectively vanished since 2020. The entire premise of the original alimony award, to support her post-marital living expenses and transition to self-sufficiency, has been undermined. She is not incurring those expenses, nor will she in the future, given her life sentence.
Life in the Department of Corrections.
22. Continuing to enforce alimony under these conditions would serve no support purpose. It would amount to an impermissible windfall or punitive transfer of resources from the child via the sole custodial parent to the incarcerated parent. Florida law does not countenance alimony as a reward or punishment. It is purely to meet the needs of a dependent former spouse, if such need exists. Here, they do not. 23. In Waskin v. Waskin, for example, a former husband's post-dissolution incarceration led him to seek relief from alimony due to reduced income. The third DCA invoked the clean hands doctrine to deny relief because his predicament was caused by his own voluntary actions. 24. The court held that equity will not relieve a party of an obligation when the, quote, decrease in the former husband's financial ability to pay, the requisite substantial change in circumstances, has been brought about by the former husband's voluntary actions. 25. While Waskin dealt with an obligor trying to avoid payment, the same equitable principle should apply on the flip side of the coin. A family court should not compel one party to continue paying alimony when the recipient's need no longer exists due to the recipient's own voluntary misconduct. 26. The former wife cannot come to this court in equity and demand that her former husband shoulder a financial burden that her own actions made pointless. Damn. 27. In summary, any claim by the former wife that she is, quote, owed alimony now is both invalid and inequitable. She has no current need for alimony support, and compelling the former husband to pay would divest resources from the minor child, effectively harming the child to create a jailhouse bankroll for the former wife. Florida's alimony jurisprudence does not permit such an outcome. Period. So that was his argument against alimony. I mean, it is just the easiest argument ever. Any other person with a modicum of intelligence wouldn't have even made these claims for alimony given the circumstances. She no longer has any need, and these are just wants, me's. Moving on. Child support arrears. 28. In addition, the former wife seeks enforcement of the $100 per month child support that the former husband was ordered to pay under the original judgment. 29. That provision made sense only in the context of the parenting plan then in place, when the former wife had significant time sharing and would expend funds on the child's care during that time. 30. Once the former wife was jailed and the child came to live full-time with the former husband, the entire logic of that child support arrangement was upended. From that point forward, the former husband has been the de facto and now de jure custodial parent, and the former wife, if the roles were properly realigned, would owe him child support. Period. This guy is eating her up.
Bon appetit.
31. Florida law does not excuse a parent's support duty simply because of incarceration. 32. In Wilkerson, the 5th District has noted that, quote, the duty to support one's children pre-exists other duties. It exists as a result of parenthood and came into force before any criminal conviction. 33. In other words, the former wife's incarceration did not terminate her obligation to contribute to the child's support. It merely made her unable to do so, for which the former husband and the child have become the consequences. 34. Over the past 5 years, the former wife has paid zero towards the child's needs. She has also failed to exercise the court-ordered visitation, for obvious reasons, and failed to partake in decision-making for the child. 35. These failures put her in violation of core aspects of the final judgment, which expected her to be an active parent, which one might argue she could not help being physically... Okay, I am going to cut in here because in my screenshotting, I accidentally cropped this one. And at first I was like, oh, you know, maybe it was at the end. But no, the part I cropped out was actually very important. So picking up on that sentence, while one might argue she could not help being physically absent, the fact remains that this predicament was caused by her actions, and she has not even attempted alternative means of support. For instance, arranging for relatives to assist the child financially. Boom, that is a point that I haven't heard of, or I haven't heard of a lot, and I haven't really expressed a lot of. I've told her to reach out to her family and beg her family for herself so that she can leave Brian and her son alone. But I never even thought that she should have been reaching out to them to see if they can help her son. Because he's right, she still has a financial obligation and a parental obligation to that child. She can't fulfill the parental role and says she can't fulfill the financial role, but she doesn't even try. He's absolutely right. In the messages that we've gone to, even though we only went through 2 months worth, every time she messaged her brother, one, it was like a love bomb / insults sandwich. And 2, it was always about her. Never once did she ask for anything for her son, or even care to check in on him. Say, hey, Brian's not buying me these Christmas gifts that I want to get him. Can you do it for me? Can you take him this fish soap, this metal Fujimura bookmark, all of these things? The teddy bear, I don't know. But no, you only ask for yourself. You haven't looked out for anyone else to see if they can help your child, only to see if they can help you. This is a beautiful point. I'm so glad I double checked because this is a point that she never addresses, even once. She likes to say she has no one and that she can only call Brian. and then she hounds her brother for money. I just feel bad for the brother because it's like, oh, hi, she says you don't exist and that you don't help her, even though she's blowing up your phone and you are helping her and you are encouraging her, and that just doesn't matter. But yeah, let's make a quick little detour to see the messages in those 2 months that she sent to her brother. See, who is she concerned about? Philip, the brother, introduce new character. Welcome to the stage, Philip Paulsen. I am so sorry for what you're about to go through, but here we go. Hi. Yay, it finally worked. Unfortunately, it cost money to message, 50 cents. But you get, I think, 30,000 characters to write. Of course you do. And of course you found out it's 30,000 characters after sending 1,500 agains and agains and agains. Oh, she's proud of it. She's proud of figuring out that there's 30,000 characters. Right now, I only have 39 cents. I wonder why. I wonder why you only have 39 cents. And I've been waiting for Brian to add more for 3 days now. Sorry for the COD, but I'm just happy and excited we're connected. The tablets are for toddlers and painfully basic, but at least it's another form of communication. Just know I love, love, love you. Talk to you later. Smile. Book ordered. Hi again. Have you had a moment yet, please, to check the status of the rule book? I've got all the paperwork ordered. Thank you, but need this to put everything into play properly. Hope you're smiling and having a good day. Burr loves. Bonds, one of the first responses we get. Book ordered. It got sent back again. I just ordered it to come here and then I will mail it. I got you coloring books, so that may have been the issue. I don't know. Hope all is well. Keep your head up. Love you. Nice and supportive. Book ordered. What the fuck? Cancel the order you placed to have shipped to your house. I can only receive orders directly from the distributor and with a receipt. What was the reason? Are you positive it's soft cover, which is the only type I can receive? What date was it returned so I can see if an officer can call the mailroom and find out? Are you positive a gift receipt was included? Do you have my address correct? Sarah Boone, 205623 FDC, but I can't do anything without this, as you know. Thank you for the coloring books, but I really need the other the most and first. Please, if anything, if you want and can, please add to my commissary account since I'm in the negative and can finally get some coffee Brian keeps telling me he ordered for ongoing 3 months instead of the coloring books, please, if you can. Again, the book is the prize, and I am grateful no matter what. Your sweet gesture of coloring books is a blessing. No, I am beyond grateful, and I love you for your support and kindness. Let me know what you think and confirm that you have received this message so you know everything and I know what to plan on. Thank you always, Philip. Hi again. Doing okay? Hope you're having a super day and feeling good. Got any updates? Hi. What's the status? Just waiting for this still, and the torment and withholding from Brian of everything is growing daily, weekly. This is the 3rd week he has decided to not provide me with anything, food, stamps, socks, etc. I've sent asking as he makes me do just to tell me maybe. Then nothing happens. I haven't even had a video visit with him to open Christmas presents Brian keeps telling me he ordered. I need to get him in court. I can't take much more of this. Truly. Thank you, Philip. I love you lots. I'm holding your book in my hand and I'm going to print out pics Monday and then mail it to you. Breathe and relax. I had to buy 5,000 credits to email you also. Stay strong and I will tell you once I mailed it out this week. Love you. To brother. Stop! I cannot receive the book from you. It has to come directly from the distributor. I sent you 2 messages telling you to cancel the order and place again to come from Amazon or wherever you're ordering. This is why I get so frustrated, and I know you are too. But there is criteria that has to be met or the entire order gets sent back. Soft cover only comes directly from distributor. A gift receipt or receipt must be included in the order. My info must be correct. Sarah Boone, blah, 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 blah. Don't waste money sending from you. Please, please, please please reorder so I can finally get this book to get asshole Brian in court. He's withholding me money again for the third week and I have nothing. Please, Philip, I cannot take much more from him. Let me know you got this. Thank you. You know I am grateful. Tired, sad, but grateful. She sends this within the half hour to her brother. And thank you for the pictures you're sending. Very excited to receive. The other girls, too, who have been asking. Thank you also for the credits. You have to transfer them to me from your account. I love you. Thank you. This isn't forever.
Court sentences you to life in the Department of Corrections.
Let me know about the book. My number is da 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 da. I forgot to add a 0 in my other message. Did you really put $50 on the tablet for messages? I could use that for my commissary. Brian is refusing ongoing a month now, and I need stamps. He won't give me because he knows the paperwork is about him to the judge. He's told me 4 months he's ordered effing coffee. He just called me a murderer on the phone this morning after messaging him, trying to get him to add funds. He keeps telling me he did or is. Just transfer some from the credits if you can do anything at all. I'm in the negative $49.25 anyway, so I'm probably too far gone at this point. Sad, tired, WTF'd. Let me know what's going on. One day, I will have good news to tell you. WTF. See, it's never good enough, Philip. It's never good enough. To your brother, hi, what's happening? What's going on? Hope you're having a nice weekend and have lots to look forward to this week. Got any updates about this spectacular book? I haven't heard from you, so I don't know unless I ask. Going on a whole month with nothing from Brian except lies and bitterness and a hard time. Every time. Nothing. Can't do it much longer. Do you know how to transfer your credits you said you purchased? They're still not showing up. Smile. I am because of you. Thank you forever. Love you. And I wish I could say I'd be surprised, but I mean, she speaks to her son like this. Why would she not speak to her brother the same exact way, with the love bomb and then the attack when you do something I don't want you to do? But like Brian's attorney said, never once asking for him to help the child whatsoever. Not thinking about that obligation at all. She's just thinking about what she has to deal with. And I could hold more empathy for it if there was this self-awareness of the extra burden she is causing and the lack of benefit or action that she brings. She brings nothing good to their life whatsoever. Not a single positive. I mean, truly, what does she bring good to their lives? Whenever she talks to Brian, it is purely to insult, demand, condescend, and ridicule. And if you do say something nice, it's only after getting what you demanded. And you can say bringing love to your child, but when your love is overbearing, insensitive, and emotionally dangerous, the best thing you could do for them is to give them the space they are begging you for. But she has a history of not caring if people beg or not. So then you have to get the law involved. 36. The former wife is, in effect, in continuing contempt of the spirit of the parenting plan. She has utterly defaulted on her parental obligations. It would be grossly unjust for the court to enforce a financial right in her favor, collecting money from the former husband when she has given nothing in return, and in fact has created additional burdens for the former husband and child. 37. Even if this court were to determine that some portion of the accrued alimony or child support technically remains enforceable, equity demands a set-off for what the former wife should have contributed, but didn't, to the child's care. 38. Florida courts have held that although child support is for the benefit of the child and not a debt between parents, an equitable set-off can be applied in where one parent owes child support arrears, but the other parent also owes a support obligation. And, quote, compelling equitable criteria and considerations justify an offset. See Suarez v. Suarez, but 39. Here, the equities overwhelmingly favor a complete offset. 40. The former wife complains of $6,100 in unpaid child support, money that would have been paid to her, not directly to the child. But the former husband has spent far more than that directly on the child's needs since 2020, effectively covering not only his own share, but the former wife's share of support. 41. The former wife, if roles were reversed, could have been obligated to pay significant child support to former husband for the past 5 years, obligations she has not met. 42. Thus, if the court were inclined to enforce any arrearage on the original support, the former husband respectfully requests that the court apply an offset in the full amount of the former wife's unfulfilled duty to support the child. 43. The compelling equitable factors here include 1. The child has been exclusively supported by one parent while the other was absent by her own doing. 2. Any money paid to former wife now would not go toward the child, but likely toward former wife's personal commissary or other expenses unrelated to the child. And 3. Former husband has incurred all child rearing costs without contribution. 44. This is precisely the type of scenario where an offset is warranted to prevent unjust enrichment. 45. In practical terms, an offset here would likely zero out any claim former wife has for unpaid alimony or support. 46. Finally, it bears emphasizing that the child's best interest would not be served by taking money out of the household that actually raises him, the former husband's household, and funneling it into an incarcerated parent who cannot use that money for the child. 47. Florida's child support system is designed to benefit children, not to enrich one parent at the other's expense.
I want to see the receipts.
The court in Suarez observed that, quote, child support belongs to the child, even though the right to receive such support on the child's behalf vests in the payee parent. 48. Here, the child support in question effectively belongs to the child's household, which is with former husband. The child has in fact received the benefits of those funds directly from former husband. To remove those funds now and send them to former wife would be to take them away from the child. Such a result would contradict the very purpose of support orders. 49. In conclusion, the former wife's claims for enforcement of support ignore the realities of the situation and the equitable powers of this court. The court should deny any relief for alleged arrearages or unpaid support. 50. If any arrear is recognized, the court should find that it is fully offset by the support the former wife failed to provide and by the extraordinary expenditures and sacrifices made by the former husband to raise the child alone. 51. The former wife's one-sided accounting demanding every penny of support from former husband while acknowledging no corresponding obligations of her own should be rejected. Equity, fairness, and the child's best interest all compel the court to refuse enforcement of the original support orders under these unique circumstances. Unclean hands and attorney's fees. 52. The former wife comes to the court with unclean hands,
You nasty.
a prerequisite for receiving equitable relief, including an award of attorney's fees in a family case, is that the requesting party has acted equitably and obeyed court orders. 53. The former wife, however, is in continuing contempt of the final judgment's time-sharing and support provisions. She has not exercised parenting time, not co-parented, and not contributed to the child's needs as required. 54. While her incarceration may excuse physical non-presence, it does not excuse the willful disregard of her parental responsibilities. By committing the crime that led to her imprisonment, the former wife effectively willfully violated the parenting plan's fundamental assumption that she would be a present, law-abiding parent to the child. 55. The court in White v. White noted that a party who has not made a good faith effort to comply with court-ordered obligations, there the husband failed to pay alimony and provide insurance, comes to the court with unclean hands
Nasty.
and may be denied relief. 56. Similarly, here, former wife's hands are unclean.
Little nasty.
She has not, quote, done equity toward former husband or the child. Equity should therefore bar her from recovering attorney's fees or any affirmative relief until she has purged her own defaults. 57. It would be fundamentally unfair to reward former wife with fees or to sanction former husband when she herself has flouted significant obligations under the very same final judgment she seeks to enforce.
Yeah, double homicide.
Bitch.
No, I'm sorry.
That was a good mic drop moment for him because, yeah, he said it right. If the roles were reversed, can you imagine if the roles were reversed and how she would act? If Brian killed his then girlfriend and then you had to take on your son full time, and then Brian is begging you every single day, harassing you every single day, calling you a terrible person every single day for not giving him money. Could you even conceive of giving him a single penny? No. But because you are you think that just because the roles are reversed, everyone is still supposed to cater to you and give everything to you despite the fact of everything that you've done to put yourself in this situation which took resources and lives away from you. 58. Florida's Supreme Court has made clear that trial courts may consider a party's conduct and the, quote, circumstances surrounding the litigation when deciding attorney fee requests in family cases. 59. In Rosen v. Rosen, the court held that while need and ability to pay are primary factors, the court may consider factors such as the merits of the parties' positions and whether the litigation is being used to harass or frustrate. That part. 60. The court specifically noted that if an action is frivolous or brought in bad faith, the trial judge has discretion to deny attorney's fees to the offending party. 61. Here, the former wife's position and motion is frivolous given the reality of her situation. She seeks to enforce rights that have been effectively lost due to her own wrongdoing, and she makes inflammatory accusations, e.g., quote, parental alienation against former husband who has simply protected the child from trauma. 62. This is precisely the type of scenario where the Rosen decision would allow the court to deny any fee award to the former wife, regardless of financial disparity. 63. Further, imposing fees on the former husband would likely detract from the resources available to support the minor child, again harming the innocent to reward the wrongdoer. You should have just said guilty, but it's fine. No, I was wrong, because just like everything else in this motion, this lawyer chose that word specifically, and it's just to get another tiny jab in. I have made innumerable requests and sent many letters asking for aid from all with no success or assistance, listening, or care by anyone other than myself trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. 64. Even if the former wife could show some need, the former husband simply does not have the financial ability to pay her attorney's fees. He is a single father
Who works 2 jobs, who loves her kids and never stops.
on his own. Any income he earns goes to rent, groceries, childcare, school supplies, and the like for the child. Meanwhile, the former wife's living expenses are paid by the state. 65. In effect, former wife is asking the court to order the family's scarce money to be diverted from the child's upbringing to pay lawyers to litigate on behalf of a mother who is in prison for murder.
Yeah, double homicide.
Bitch.
No, I'm sorry.
Such an outcome would be inequitable in the extreme. Florida's fee statutes is intended to ensure both parties have similar ability to secure counsel, not to oppress one party or subsidize vexatious litigation. 66. Given the entirety of circumstances, including former wife's egregious conduct and former husband's limited means, the only equitable result is to deny former wife's request for attorney's fees and costs. 67. Moreover, to the extent former wife seeks sanctions against the former husband or his counsel, this response emphasizes that there is absolutely no legal basis for such sanctions. 68. Former husband has acted within his rights by seeking modification and by caring for the child. He has not violated any court order in bad faith, and any claim asserting that is without merit. Wherefore, petitioner, former husband, Brian Boone, respectfully requests that this honorable court deny the former wife's motion in its entirety. Specifically, former husband prays for the following relief. A. An order denying former wife's request to enforce or collect any alleged alimony arrearages. B. An order denying former wife's request to enforce or collect any alleged child support arrearages from former husband. C. An order denying former wife's request for sanctions against former husband and his counsel. D. An order denying former wife's motion for attorney's fees and costs. E. Such further relief as the court deems just and proper. Certificate of service. Yeah, so that was Brian's response motion. Mr. Martell did an excellent job. From the lawyer's perspective, it's not like it was actually that hard of a case or anything, but to be just the perfect amount of petty while also completely dismantling any and every argument that she has ever spewed from her unhinged jaw. The biggest thing he really clung to was equity, fairness, and the child's best interest, which are going to be the 3 pillars that the judge makes this decision off of, basically. And he asserts equity involves an offset, even if anything was applicable, even if she could get any kind of money, there should be a complete offset for that. And I think there's another motion where they tallied up the money that she would have owed, and she would have owed something like $30,000+ to him. She would have actually owed that money, not these fake numbers she just throws in the air, which would cancel out because she's asking for $61,000 for 2020 to present, 2025. But he put in this motion to stop paying in 2022. So she could only collect for those 2 years until he originally put in this motion. Then from that moment, he no longer had to make those payments until this matter was resolved. So that's about half the time. Cut the $61,000 in half, $30,000. His $38,000 approximation cancels that out. So they should be square. She likes to morph the definition of equity and fairness. She is acting like she is still out in public. She is saying fairness means we both have the exact equal things, meaning I have everything that Brian has. I have access to everything. I have all of the privileges. It's only fair, 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 fair. She goes on her little fair tirade all the time.
Drug you up there. You didn't float up damn stairs.
Okay, well, it's not fair. It's not fair that you guys keep trying to say that that's what I did. See, this is what happens. It's not fair that you guys, just because he has those, automatically blame it on me. And it's, again, it's not fair that you all are assuming that the marks that he has on him are from me. And the whole time frame thing, it's like, it's
Regardless,
that's not really fair.
Regardless, waiting for him, it's not like you.
They see you every day. How many,
Oh
you had
my
two neighbors you
gosh.
went to and asked to go
See,
use the
that is
restroom
just
and
not
you said,
fair.
No, hold on.
It's wrong and it's unfair.
You certainly entitled to that opinion.
And it runs flat based off of her own behavior. The audacity for her to ever say that something is not fair when George is dead will always blow my mind, because it's like she can't even, because she That's exactly right, Linda. But she can't even see the unfairness of her own situation from society's and the world's perspective. It's unfair that you get to complain every single day of your life living in jail. Meanwhile, George is dead. His kids are walking around fatherless. His parents are still alive. You get to talk to your son. Maybe he doesn't want to talk back to you, but you still have that ability. They don't. None of that is fair. What you've put on your family, on your son, on your former husband is not fair. And equity is just fairness and justice and trying to balance that, because it's not equitable just giving everyone everything equal. Because if you already have advantages, getting equal supplies as the person who is disadvantaged is only going to elevate your position further. She thinks equity and justice would be getting her negative bank account out of the negative and making it positive, equal, fair, just with the husband's assets and finances and this and that, when that would be the most unjust thing imaginable for a murderer, like he says, to be rewarded for her crimes. She had the chance for mediation where they could have come to some, regular agreement or some reasonable agreement, but no, you wanted to play merry-go-round, and every time that his lawyer sends letters and responds, Brian's paying for that. All of that is billable, so we don't have time to go back and forth with you, because who's paying for that? So now we have to go to trial, and you are going to lose everything yet again and be shocked, even though you were offered a 15-year plea deal and had, as long as you survived healthy, a 100% chance to potentially be back in your child's life if he would allow that. The parent who actually cares about their kid would have taken that plea deal in a heartbeat, especially when they filmed themselves and have seen that video. It would be one thing, again, if this video didn't exist and it's all speculation, maybe you can fight it out, maybe you can explain your situation, but you filmed yourself with the motive and probably some of the cruelest last words you can say to someone. And yet you wanted to go for it anyway, because you thought that you were entitled to leave because you wanted it. You. Same thing here. You could have gotten mediation. You could have came up to something reasonable. But you wanted you. And now, yet again, you're going to trial. And you are 100% going to lose this trial and be shocked when not only your alimony is cut, but your parental rights are cut as well. Because if he shows them these text messages, that shows, like he said, he's just trying to protect his child from trauma. These messages are traumatizing, especially in context. She's not just mom, she's mom the killer. and Mom the killer is yelling at you and getting upset and getting angry, and you just see all the vengeful, angry, hateful spite that we saw in all these other videos jumping out through these messages. These are threats. These are intimidation, coercion, isolating, alienating tactics, just trying to guilt everyone around you into doing what you want. And when you were on the outside and you weren't in jail and people could hold all the pity in the world for you, oh, you don't have family, you have no one, da 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 da, you were able to scrape by with that. But now all the sympathy is gone. But I digress. Let's move on to the next document where she responds to this response. Sarah K. Boone, respondent. Respondent's response to petitioner's motion in opposition. Comes now the respondent, Sarah K. Boone, appearing pro se, and respectfully submits this response to petitioner's response in opposition to former wife's pro se motion seeking enforcement of alimony, child support, sanctions, and attorney's fees. 1. Pro se representation, limited access to legal files, and efforts to secure counsel. Respondent is currently incarcerated and serving a life sentence
to life in the Department of Corrections,
with appeal pending. As such, she has limited access to legal resources, computers, and telephones needed to produce proper legal documentation. Respondent is making every effort to comply with the court's procedures and protect her legal rights in accordance with Bounds v. Smith, which recognizes the right of inmates to access courts. Respondent has made extensive efforts to retain legal counsel and has written numerous letters to attorneys, including the Legal Aid Society. Her limited third-party resources have also made multiple calls to attorneys in Orange County. However, due to financial constraints and her status as incarcerated, she has been unable to secure representation. Respondent acknowledges that her circumstances are a result of her own actions. What? The respondent recognizes that this is a result of her own actions. Wow, her circumstances are a result of her own actions. This is the first time, I'm going to go ahead and say it, this is the first time she has ever taken accountability or responsibility for what she did and why she is where she is because of what she did. At first, I didn't do it intentionally. And then it swayed to, I didn't do it at all. He did it to himself. Then it was the alcohol did it. That wine, Woodbridge Chardonnay, is a literal serial killer. Then it moved to, then I did do it, but it was only because of self-defense because George made me do it. But this is the first time she is saying, I am where I am because of what I did. Wow. Congratulations, Miss Sarah Catherine Boone Paulsen.
Need escaping. The killer is eating my peach. Help me.
For showing some self-awareness or acknowledgement. It's the most basic acknowledgement you can possibly make ever, but you haven't done it. For 5 years, you have refused to acknowledge that you are where you are because of your actions. It has always been framed as someone else's fault. It was George's fault for beating you. It was the family's fault for not stopping him. It was the police's fault for warping your words. It was the lawyer's fault for not contacting you. It was the judge's fault for not listening to you. It was the warden's fault for being unfair. It was everyone else's fault but you. You were the victim of life. And you finally admit you are where you deserve and need to be because of your own actions. But asks the court to consider her sincere efforts. She is simply trying to maintain a relationship with her son and to secure her basic needs while incarcerated, as well as continue her legal efforts regarding her appeal. See, and this is also a major issue I have with all of her things. She is now diluting everything that she has put in her last motion to, I am simply just trying to maintain a relationship with my son and get basic necessities. Then why in your motion are you asking for $61,000? Is that you trying to maintain a relationship with your son? Is that you getting your basic necessities and trying to get your legal whatever? No, that's you asking for everything you feel entitled to. You feel like he owes it to you and you demand it. Now you're saying, because you got your ass handed to you by Mr. Martell and you realize he poked every hole you could have ever imagined and brought up a lot of points that you were hoping that wouldn't be talked about because it really does make you look that bad. Now you just want her to see your effort and that you're trying. You only want this relationship. And she's done this in the past where she'll write motions and she'll demand the world these real big motions and then cower away from it when everyone's like, absolutely not. And she's like, well, I only wanted this. This is so, just a little thing. And it's like, you weren't reasonable in your original motion to begin with. So we're going to take a little detour and look at one, because the one that's coming to my mind is about the hand shackles and that whole debacle where she wrote this whole motion saying that she wants to be just as free as everyone else in the courtroom. And then when people came up and said, hey, no, you have a violent history and a charge for a third-degree felony strangulation, so we don't think you should be unshackled. And it goes back and forth, round and round, and you were just like, all I want were to have the handcuffs removed. And everyone's like, well, that's a whole different argument.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Then maybe you should have put that in your motion instead of saying, I want to be unshackled, uncuffed, moving freely, comfortably, equally, efficiently, advantageously, all these other adjectives. You wanted the world. Now you just want the cuffs off. Be specific. She wants everyone to interpret what she's saying and filter it into the best light possible so that you give her the best outcome for whatever she just throws at the wall. No.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand. By you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning accordingly, equally, and comfortably while utilizing the courtroom.
Unshackled, unhandcuffed to function equally and comfortably while utilizing the courtroom. Whew. Now that's a title.
All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed The defendant is simply requesting equal, comfortable, functional movement.
You can tell with her facial expressions, she hates having her own words thrown back in her face. Because once she hears it out loud, she knows how it sounds. That's why she doesn't talk this exact same way that she writes. Because when she gets behind her, not keyboard, behind her big ballpoint pen, she grows all this strength and she feels like she can say anything about everyone. And then having that defiant language set out in open court in front of everyone, you can tell it doesn't sit right with her.
To achieve advancement in her forfeited right to counsel by the court.
Okay, but damn, these camera angles are shady. Not you zooming in on the pink cuffs.
Which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to
no, not even closer.
function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
Then you could have just said that from the beginning. But no, it had to be this whole big hubbubaloo of, I need to be just as equal and free as everyone. And then gets mad at people for not asking you endless questions. Just like you were mad with Mr. Martell for not responding to your lack of cooperative response to his letter asking you to schedule dates for mediation. And you say, why do I even have to schedule a date? Who's this? Who's that? Who's this? Who's that? And they say, no. She thinks using big words and trying to ask things in a professional manner is actually asking something in a professional manner. She just puts words together thinking that she sounds smart and says anything she think will get a response and will inflame someone to want to do what she tells them to do, or at least to react. That's why there's that saying of like, indifference is worse than hate. That's why you have to forgive people. That's why you have to not hate people, because that's what they thrive on. They thrive on some kind of interaction and response. If you don't give them that interaction, they lose their mind, case in point. People are not going on the merry-go-round. She's insulting them and they just aren't responding and are moving on, and she can't take it. That's why she double and triples down and insults and berates and demands more, because she will get a response from you no matter what. Unless you're Judge Kranick. Then you get to sentence her to life in prison.
The court has had the opportunity to life. Review the evidence and testimony that was presented at trial. To life. The victim impact statements to life. Presented here today. To life. The statements of character witnesses. Life. Both orally to life and in writing to life. Dr. Harper's report to life and testimony, life. The defendant's testimony to life. Pre-sentencing investigation to life. The arguments of the state to life and the arguments of the defense to life. Court pronounces sentence as follows: to life. Ms. Boone, life. Court sentences you to life in the Department of Corrections with credit time served that Madam Clerk will provide to you momentarily.
Mic drop and walk out, which I know for the rest of her life will eat her alive. Him not saying anything. Even Paulina the Plane is upset because we all wanted to hear what Kranick had to say and how he was going to lay into her and tell her what she needed to hear. But he's smart enough and wise and experienced enough to know someone like this is not going to get the message regardless. Some criminals, you can give them a tongue lashing and hope that it's going to sink in with them and that they actually understand the gravitas and the gravity of the situation. But he knows there's nothing he could say that would penetrate through her defensive barriers of just avoiding accountability and accepting reality for what it is. So he did the thing that would eat her alive more than anything, and that was to give her nothing. She wrote how many letters to him, she said how many things in front of him, and he never gave his true opinion about her or an opinion about anything regarding her whatsoever. He was always even-tempered, even-headed, and only gave legal responses. And that's how you beat an abuser like this, who will never stop until they get a reaction from you. She even said in one of those messages, I message as many times, in the text messages we reviewed, I message as many times as necessary to get a response. We don't have to talk to each other. It's one time to just get me what I need and can have. You make it a million. Do you really want me in your life so much to make me contact you every day, every day, every day? I ask as many times as needed to finally get an answer. If not this way, which would be more simplistic and less time consuming, especially for you in Gainesville, than in court, where you can answer everything when the judge asks you or orders you to answer? Don't you think? The reason for a very needed court date is simply over you not cooperating. You understand that, right? Then with all my paperwork, messages, requests, concerns, questions, etc., I'm going to submit. Everyone will see it. It's simply you taking up everyone's time. You. So simple. Please be part of the solution this year, not the problem. Cooperate and just work together, Brian. So simple. Think about it. Because she's used to, and her whole life tactic has been to wear people down until they give in. And now she exists in a structure that is meant to be flexible with people like her and not meant to stall itself in these endless circular arguments with criminals who need to be locked behind bars. Sorry for that little side note, but similarly here, she is now saying, I just want to have a relationship with my son and some basic little living necessities. That's not what you asked for in the motion. So you have to deal with the answer and the consequences of asking for things in the way you ask for them. 2. Recognition of respondent's role in raising the child. Respondent respectfully asks the court to recognize that prior to her incarceration, she was the primary caregiver for her son while petitioner pursued his career. Respondent was responsible for the child's day-to-day care, including education, medical appointments, and overall well-being. While respondent understands the petitioner's concerns regarding her current circumstances, she requests that her past contributions to raising her son be taken into account when considering parental rights, alimony, and visitation. It already has. Your past contributions were already taken into account during the original alimony settlement. They took all of that into account, and that's how they came up with the numbers that they came up, the terms that they came up, and the reasons for why they did that. You don't get to redo that every single time for new things here, new things there. And no, you are not the primary caregiver with your son. Just because you didn't work and Brian did, doesn't mean he wasn't also an involved parent. And normally this is a very valid argument for dependent spouses who do give up their careers and give up their ambitions for that the other more successful financially partner can exceed in their career and this and that. And alimony, exists because you can't do it on your own. If you're in this marriage, you don't get your own successes all on your own because you had a partner who was holding the space for you to make these things happen. That's why alimony isn't necessarily assessed for things the wealth people had before the marriage, but is mainly focused on the wealth that was amassed during the marriage, during that partnership. And by all accounts, you weren't a really great parent. I mean, you had CPS called on you for literally zipping your child in a suitcase, and that's only because that's what you posted to Facebook and someone else saw. We don't know what you did to that child that was actually dangerous, but your drunk self thought it was hilarious in the moment. She makes it sound like petitioner pursued his career as in he wasn't in the home, flew around. And I have people in my life who are in that situation where they do have a single parent who's like not single, but there is like a single parent who is the primary caretaker while the other parent is not there, just not present whatsoever because of their work and literally pursuing their career. That is what that language is for. She is trying to say, I mean, we were in the same house, all living under his paycheck, and he got off work every day and had to come home, and then I made sure that he took care of this child as well. And motherhood and parenthood is a lot. Never going to take away from that. That is a job in itself. So absolutely you are deserving of some things in your initial divorce, your initial alimony settlement agreement. These were valid arguments. However, after you murder someone in such a violent and horrific way that you were sent to prison for the rest of your life.
To life in the Department of Corrections.
And the circumstances have now substantially changed. Your past contributions cannot overwrite your present circumstances because of your most recent actions. You being a good wife all you want doesn't make you not a killer now. And that's what we're assessing, is because of everything that you've done now, what has to change from back then. So we see she's backed away from all of this, I deserve this, I deserve that, Now it's, please take into account my past. What I did in the past should be more than enough for me to be okay now. And she did that in the interrogation too, when they're sitting there being like, hey, it seems like you hated him, you're killing him, you're laughing at him while he's begging. Oh, but you don't know what I've done for him. You don't know all the things I've done for him. I would do anything for him. I have done everything for him.
And I feel like I can help him. Like, I feel like I could help him, which I did, because he came a really long way from where he was in Philadelphia to moving back to here and to dealing with everything else that he's been dealing with. Mm-hmm. I've really helped him. I've bailed him out of jail, 3 times. I've gone to every single hearing and every single arraignment, everything that I did for him. Gone to see all his public defenders, go to the state. I've gone to the state. I did everything for him because I'm trying to help him, because I had hope in him. And he was trying. He was really trying.
And handle taking care of him, and
I never stopped. I never stopped. That's what I'm here for. I never stopped. I'm here now because I'm still trying to help him.
Yeah. We just don't, it's unexplainable how he got these injuries, and
I have no idea.
You were the only one with him.
They're not messing around. I even went down and met his probation officer, which I say she's wonderful. That's one of my questions too I need to talk to you about. Hugged me and said how much she knows that I take care of him. She called me personally one time when George was at work, when he was working. 42-minute phone call. She and I just saying how grateful she is that George has me. And she knows how hard I'm working to help him, just as she is and just as the classes will. I wouldn't do that to him.
So, I just...
Well, it's not like, again, I don't think you all understand. It's not that was not my intention.
Well,
y'all don't have any idea what I've done for him.
But by your acts, and that's exactly right.
You all?
Please sit down.
Listen to me.
Please sit down.
You all, listen. I did not intentionally kill him.
So your intention...
I don't know what it is I need to do or how to do it or what to say or how to say it.
But what was your intention?
Everyone knows. Everyone knows. Everything that I've done for George and love him and continuously helped him throughout his life with me and made him a happier, better person.
And everybody has their limits.
Everyone knows that.
Everybody has their limits.
So it's like, okay, so while we're in a good place right now, I'm going to snap? Is that what while we're in a good place right now?
You did.
Yes. Absolutely.
So what, guys? So what? I don't know what you want me to say. other than it was not out of maliciousness or intentional. I don't know what or how I can say it. I love George. Love him. To this day, still. Love him.
Love makes you do crazy things.
It's not one of those things where it's like, oh gosh, you know what, I've done enough for you at this point. I never gave up on him.
Okay.
Why I'm here today, I'm still not giving up on him. I would do anything for him.
Well, you gave up checking up on him.
Wouldn't let him out of the suitcase.
Oh gosh.
Because she thought then, as she is asserting now, that because of what she did for him, did for them in the past, it means it's okay she killed him, meaning she still deserves $61,000. And just forget about the murder, forget about the beratement, the hundreds of requests, the verbal abuse recorded, because she likes to record everything, recorded in text and audio. Thank you, Linda. I needed to land this plane. No offense, Paulina, but a mess. The past is in the past, we're in the present, and you'll still be in prison in the future. 3. Parenting rights and request for visitation with minor child. Respondent fully understands the petitioner's position regarding her parental rights and the potential limitations due to her incarceration. Under Florida, the court has the discretion to determine rights based on the best interest of the child, even for incarcerated parents. Respondent respectfully asks the court to grant her the opportunity to have a set visitation schedule with her son, in accordance with Florida, which allows for the establishment of a parenting plan, even in cases involving incarcerated parents, if in the best interest of the child. Hard stop right there, because that is the exact point. If in the best interest of the child, it would be in the worst interest of the child to force a visitation schedule where he has to go interact with a parent who clearly causes him distress at the bare minimum. Yikes, can y'all tell I have morning voice right now? Recording schedules are wild, I'll say that. Anyway. And I don't know if I'll find it, but Brian said in one of the text messages that we covered that he was going to have the son come in and be taken to judge's chambers so she can't be around him, and have the judge talk to the son and get his answers that are uninfluenced. Call back tomorrow. Quote, I don't want to talk to you. When I asked why you keep telling me to call you in, quote, a couple days, why you won't respond to any of my messages on the tablet. As I explained, I did not want to speak to you either, and is why I keep sending messages to not have to from your emotional stress and cruelty every time. Why do you keep telling me you're going to respond? Quote, I'm going to have our son speak to the judge about you, taken into his chamber so you can't hear or know what's being said about you. Fucking work, Brian. I know that's right. What exactly would you have him say, or could he? Our son has told me he sees how mean you are to me, call me names in front of him, doesn't buy food and hangs up on, also tells me about your supply of cigarettes, often running to the store for, and drinks you have readily available. How then are you going to use our son against me? He knows and admits he treats me the way he sees you do, and you honestly would put him in a position of having to lie and pit against me even more than you already have and do? Do you realize what you do to him? You. Remember also I said in the divorce class you took that you should understand and signed. You're doing everything exactly what you're not supposed to be with how you force him to be to me. Because she likes to say that he is a completely different person around her and not around his father, thinking that his father is the one who corrupts him, when really it could be, and it probably is, his father is the one protecting him, and he feels emboldened when he's around him When he's around you only, he knows if he says anything out of line, he's going to get screamed at. He's going to be told, you're not being nice to me. You're treating me this, you're treating me that. Me. But when Brian's there, he feels comfortable telling you he wants nothing to do with you and then hangs up on you.
We don't owe you anything and are waiting for you to be guilty so we can get out of here and away from you. I don't want to deal with you anymore. I'm going now. Click. Yelling at me so loud, the phone is distorting. So loud, former husband, his father, came in and told him to stop being mean to me before hanging up.
She is going to need a lot to make the argument that it would be for the best interest of the child. Again, she lives in the stereotype of, because I'm a mother, because I'm a woman, it is always going to be in the best interest of the child if I am in the child's life, and that is not true. There are plenty of toxic mothers that the best thing they could do for their child is give them the space to grow without them, at least in that moment, and give it time. And we went through the son's text earlier, but I just try to condense it to show just, her highlights. Miss Sarah Catherine Boone Paulsen's
Excuse me. You're eating.
greatest hits and beratements to her son, and it still turned out to be long. So, Brian, feel free to play this in court.
I hope your day is nice, like you, sometimes. I was hoping you would actually listen and care and make an effort. Why? It's not like I'm asking you to grow a third arm or lasso the sun. Just answer your phone. I hope one of your resolutions, if you have any, is to be nicer and respectful to your mom. Yes, I have feelings, and how much you crush them by not caring enough to simply plug in your phone. Would you make sure it were on if Addison called, or Mary, or anyone other than me? If you are choosing not to talk to me, I wish you'd just man up and tell me so I can stop looking like the fool you are making me out to be by calling just to be yelled at, called names, or hung up on. If you have nothing to say to me or care enough to include me and share your life, just be honest and say so. You are my son. I am your mom. Forever. No matter what, where, when, why. No matter anything. You can't delete, erase, blot out, omit, change, or remove. Stop being mean to me and not caring. I'm already going through so much, then to be disregarded and spat on by you is unspeakable, and for no reason. Do you delight in making me feel worse? Does it make your day knowing you make me cry and feel worthless to you? Who am I to you? Really ask yourself that. Punching bag? Daily joke? Unwanted friend? That's how you make me feel. Know that, son. I can't make you care. I can't make you love. It's your choice. Yours only. New year, new start, new everything. Your choice. Don't forget about me. Love always. Who am I? Plug in your phone. It's not nice to me to not be able to talk to you because it's not on. Remember, if your decision is for me to not be a part of your life and keep trying to talk to you, just say. Just say. Your response last time I asked was that you wanted me to be. I wouldn't know from the lack of effort and intention to make possible from you. What else can I do? Honesty and effort. Not asking much, but missing out on talking to you, my one and only son. Love, your one and only mother. Trying to call you, why can't you make sure it's charged and on and with? Effort and love? Just tried calling yet again. Why can't you? Rather, why won't you make sure your phone is charged and with you to talk to me? For how many times I have asked you and Brian, I keep using my credits that cost 50 cents each to remind you. Please plug in, charge, have with. Love and effort? You have so many things that are praiseworthy and positive to think of joyfully. Most of all, him, and also including me. Please don't ever think I'm not a part of it. I am, no matter what or where. I'm never going to give up being in it. And for you, no matter what or where, I love you for everlasting to everlasting. Always know that. Talk to you later. I call every night. Every night. You don't want to talk to me? It makes no difference when it is, as it's the same thing on the weekends. Anytime I call you, please don't think I'm not trying. It's you who are not. I hope you answer sometime. Make sure others remember how good you make them feel with all the softness, understanding, love, and positivity you can give to everyone, including me. Make a difference. Be the difference. Take the extra minute or extra effort to remember that I remember too how you make me feel, your mom, along with everyone you come in contact with. Remember, I love you. Thank you for your goodness. And she wants the court to believe that that kind of communication is in the best interest of the child. Huh. And it's just another annoyance because it's not like she doesn't see her son at all. It's just she doesn't see him as much as she would like. And so she yells and berates, which makes Brian want to send him less. So if you were acting nice and polite and correct and respecting boundaries, you would probably, I would say 100%, see your son more than you see him now. But you want to force a visitation schedule. You still have no proof or evidence that I've seen thus far that he has ever mentioned he has wanted to speak to you or talk to you, and the father has prevented that. Maybe that's out there. I doubt it because I feel like you would mention it every single day, time and date, pull it up anytime you can, but you can't. So you have to say the vaguest thing imaginable, which is just the best interest of the child. Obviously, you're going to side with me. And then she's going to get mad when the judge doesn't and say she didn't understand and she didn't this and that.
Sometimes I'll start a sentence, and I don't even know where it's going. I just hope I find it along the way.
Anyway, moving on. As discussed in her prior motion, respondent requests court to order relief from petitioner to respondent to remedy ongoing and future parental alienation. 4. Alimony and child support. Respondent previously filed a motion indicating that she does not seek child support and would like all funds returned to petitioner for the benefit of the minor child. Respondent requests to be included in the collaboration of the child support fund disbursement. The petitioner argues that the respondent no longer has a need for alimony and that he solely supports the child. However, under Florida law, the respondent's entitlement to alimony is based on equitable considerations, including the significant sacrifices she made during the marriage, the financial trade-offs agreed upon in the settlement, and the principles underlying alimony modification. And the principles underlying alimony modification is exactly why this is happening, because there's been a substantial change in your circumstances. You want to cling to the past? Past won't help you here. You also didn't address the arguments. You're correct. The petitioner does argue that you have no need for alimony and that he solely supports the child, and you don't address that at all. You try to sidestep and say, but under Florida law, you need to pay attention over here and talk about equitable considerations, including significant sacrifices. Not going to name the sacrifices, but just the blanket sacrifices, because he also made no sacrifices by financially supporting a family as well. The financial trade-offs upon the agreement. Again, these were your arguments when y'all were putting the numbers up originally. To make these arguments more relevant, you first have to address that you still have need through your necessities. You've attempted to do that, and that he solely supports the child. You've never really overcome or addressed that. You've acknowledged that he does it, but you don't acknowledge that because he is taking on this burden and has to do this, that he needs more resources than you do. And the equitable considerations, your livelihood is paid for. Your housing, water, medical care, food, hygiene products, they're not good, I'll admit that. But they're there, and you're not paying for them. He is. He's paying for clothing, housing, food, water, electricity, all of the things.
So out of the money he already has, all of that has to get deducted. Any other emergency or standard expenses, I'm going to say even seasonal expenses, because there's always something you have to pay for depending on where you are in the year, especially for school. And she doesn't address any of that and says he just needs to manage all of that burden, but still that current present burden, but still acknowledge my past contributions and give me $61,000 anyway. And she puts up there again, I previously told you that I don't want the child support. Yeah, but you also originally asked for the child support like a fool. Realized your mistake in that you had actually no legal backing for that, and then said, actually, I want to give it back to you, the money I never had. Respondent's request for unpaid alimony is not a, quote, windfall, but her share of the equally divided marital assets. Under Florida law, courts consider alimony in the context of equitable distribution. In Rawson v. Rawson, the Florida Supreme Court emphasized that alimony serves as an economic balancing tool, ensuring that one spouse does not suffer financial hardship due to contributions made to the marriage. In this case, the respondent relinquished her interest in the marital home and the petitioner's retirement benefits in exchange for alimony. Respondent understands that her incarceration has put an increased burden on petitioner and is extremely grateful. Her request for alimony is not to put any undue strain on petitioner. Therefore, petitioner again requests the opportunity to mediate and settle for a reasonable amount that would, 1, not impact the respondent's financial capacity to care for the minor child, and 2, allow her to cover her basic and essential needs, including hygiene products, medical expenses, clothing, food to help manage her blood sugar levels, and any futuristic essentials. Well, she was getting better. At least she didn't use futuristically again. But if y'all are her friends or something, apparently like her fans are called flying monkeys. Hilarious. But if any of her flying monkeys want to let her know, futuristic still is not used correctly here. Something that is futuristic and futuristically, as we say a million times, is future-like, as though it were inspired or referential to a style we would conceive of in the future. Something is futuristic as a descriptor, not as a time indicator. I don't know if she knows this, but the word future is already future tense. You don't need to do futuristic. You can literally just say, for all future essentials. Boom. Any other future essentials. Boom. That easy. But no, you always need to try to sound a little smarter. Futuristically, nonetheless, whatever. Anyway, what you defined as essential is not legally defined as essential. You thinking you need all this, all that, and food to help manage your blood sugar, you still have not shown any of this proof that you have, 1, have these blood sugar issues, which I'm sure you do, but 2, have a monitor for any of these things. Do you work with the nurse? Do they have you check in with something to be able to check in with your blood sugar? Or are we all vibes on this and you just want your cookies whenever you want your cookies? Because the truth is, that's her new vice. Sugar is the vice you substitute. And that happens a lot in prison, especially when alcoholics and recovering addicts go to prison. A lot of that transfers into the next addicting substance there that's not banned, which is sugar. So she really just needs her sugar in order to not freak the F out, because she has no other kind of substance that way. And I'm sure there is some kind of little blood sugar or whatever, but it's not as overblown as she is saying. And also the argument for ensuring one spouse does not suffer financial hardship, you are benefiting from this. That's the one thing. You were so poor, you were literally at 0 in the negative. Could not pay for anything without Brian's money.
Yesterday, which is that, when she said her account was in the negative, so I transferred her a little bit of money to get her out of the negative. That, I mean, my alimony and stuff basically pays for where they live. So, I mean, Didn't need a ton, but I mean, she was always calling to borrow money. And
his ex-wife is bonkers. She was all over him all the time. Send me money, send me money, send me money.
Your financial situation has drastically increased. Most of your bills are taken care of. Most of your expenses are taken care of. And wants to say that this isn't a windfall. She's entitled to this because her share of the marital assets, because she gave all of this and all of that so that she doesn't suffer because of the sacrifices made during the marriage. And what's her sacrifice? What is her this and that? Is she agreed to give up Brian's retirement benefits, and that's why she is deserving of more. But you just see, even then, it's not anything that she has, earns, or deserves. It is always someone else's resource that she said, I'm giving you your retirement benefits. I'm giving you this child support. So you need to give me everything I want. And she'll say things like relinquished her interest in the marital home because she had no interest in the marital home. She was getting kicked out. He bought her out to get her to leave them alone. And she didn't fight it. She was also offered various options on how to receive this money, and she chose to take a large lump sum up front. I think it was like $20,000 to $30,000, and then to get the $1,000 a month over the 5 years or 7 years. So it's not like she left the marriage with nothing. She had $20,000 to $30,000 cushion to get herself situated. She saved nothing from that. Didn't try to get a job to add to that. Didn't try to save the $1,100 she was getting every month. Only spent every single dime and penny she owned on alcohol. And that one sentence to me read like she was writing it, gritting her teeth of, respondent understands that her incarceration has put an increased burden on the petitioner and is extremely grateful. You don't act extremely grateful, not even a little bit. You're the most ungrateful person I've ever met in my entire life. Well, I haven't met you, but seen. You don't thank anyone for anything, genuinely. And when you do give a thank you, it is only after getting absolutely everything you asked for, with the hopes of getting more. And the lawyer brought up how this is adding even more burdens on top of him trying to pay for him and his son's own essentials and housing and yada, yada, yada. But respondent is not trying to put an extra burden on him. That's why I'm just requesting a mediation, please. We just need mediation for a reasonable amount. No, you want mediation now because you're about to lose everything and you realize you should have been cooperative before and you should have said, yes, here are some dates. Please be open to any changes or modifications depending on where my health is at that time, and then we can go from there. But you wouldn't even engage. It's still that one sentence for me of you saying, number one, what is the law that says this mediation even has to be scheduled?
No one has a crystal ball. I do not know 4 months in advance my location or status, making it impossible to determine the best date to choose from which you have proposed. That being said, my questions are as follows. 1. What are the requirements under Florida law stating a mediation needs to be scheduled for the petition to modify? Please provide documentation so I can understand the practices, procedures, and protocol for this area of family law.
That is saying that you are against it. Why does anyone need law on why anything's scheduled? Do you want the law on why pretrial conferences are scheduled? Do you want the law on why court trials are scheduled? No, because they're scheduled because they have to happen, and you know this. You were being snotty, being like, why does this even have to happen? Why can't he just give me a reasonable amount and we don't have to do any of this? And now that you have to do all of this, I'm begging, please do the mediation we all agreed to do and save everyone. No more burdens. Just give me everything I need, just the bare essentials. I don't need $61,000. I'll be fine with $40,000.
5. Personal property. Respondent seeks clarification and information from petitioner regarding the location of her personal property discussed in prior motion, including her vehicle and items held in the storage unit which petitioner willfully took control of and verbally agreed to maintain during her incarceration. So for the rest of your life, girl, goodbye. He didn't address it because that has nothing to do with anything. You put absolutely zero legal foundation as to why he has to tell you where your property is. So that's not an argument he's going to combat or support. And the judge isn't going to acknowledge it either. That's not an actionable request in the way that you are asking. If you wanted this to be addressed properly, you would say, this case said this. It dealt with this kind of alimony divorce settlement agreement and exchange of property, and the court ruled that it is necessary and that each person has a right for the other person to tell them where their personal property belongs to. Then you have some legal foundation for making this request. You have none, so they're not going to even entertain it. And that stupid willfully took and verbally agreed. How you would not let him not take it? You really expect us to believe the way you act? You would say you would leave the mother of your child's things just off to the wind. All of my family heirlooms. We were married for 13 years. How could you? So you absolutely forced him into taking willfully and verbally agreed. You take anything as an agreement. He said, I could put money in your commissary next week. And you said, you told me you will, you would, you did. Why haven't you already? You warping people's words is a you issue, not the court's. Wherefore, respondent prays that the court establish a visitation schedule that allows respondent to maintain regular contact with her child, acknowledge her pro se status and limited legal access, provide a court-ordered remedy for parental alienation by the petitioner, recognize her continued efforts to retain legal representation, recognize her role as the child's primary caregiver prior to her incarceration, approve mediation for alimony, provide information regarding the location of her personal property, grant any further relief the court deems just and proper. Thank you for your patience, understanding, and judicial review. Respectfully submitted, Sarah K. Boone, pro se respondent. And that was her response to Brian's attorney's response to her absurd motion asking for $61,000. At least this was better than the first one. If she came out with this kind of rhetoric, she probably would have gone further. But no, when you come out with demand, insult, allegation, which there are still plenty in here, but not as many as the first time, then maybe your arguments will be listened to. But when you sound like a little brat just pointing the finger and yelling, everyone's going to see, maybe the convicted murderer,
guilty of murder in the second degree,
should be left alone. But this is her summary of what she wants. She wants to establish a visitation schedule that allows the respondent to maintain regular contact with her child. Absolutely not. In theory, yes, and for most situations, absolutely. But this connects to the third one of provide a court-ordered remedy for parental alienation by the petitioner. That is a huge claim and accusation. Courts take that seriously, a parental alienation. Are you purposefully undermining the relationship between child and parent? And if she were out of prison and he did the exact same behaviors of not answering her phone calls, not allowing the son to answer her messaging, not bringing him over, then you would have those arguments. But when you're behind bars for a violent crime, the protection of your son is foremost. Not the protection of you, not the protection of your feelings, not the protection of your wants. The protection of your son comes above all else. And you are a risk and danger to your son. Why? Because you're a risk and danger to everyone. So much so that the Florida court system ruled you can't be let out into society again because of your dangerous and violent behavior. The fact that this is a violent crime is really what's going to destroy any argument she has towards parental rights. If she was in there for a drug charge, if she was in there for any kind of minor conviction, then she can make these arguments more persuasive of, you haven't demonstrated a risk to the child, so your rights shouldn't be terminated. Oh, you harass this child daily? You have physically and emotionally, mentally harassed the father for over a decade?
you killed your boyfriend who you said you loved, people you say you love still end up injured and harmed and dead around you. So I'm going to say no to the visitation and let Brian decide when you get to see him. Because from everything we see, it seems like Brian is going to go with what makes the son more comfortable. And if the son is begging and pleading to see his mother, he might be that kind of person to still say no, but odds are he's going to say yes. If you have respected the boundaries that they've set, allowed them to have their own life and live their own life, then they would want to see you more and more regularly. No one wants to say, hi son, sorry you can't go to marching band on Thursday nights because we have to go to prison and get yelled at by your mom. No. And then the second one, acknowledge her pro se status and limited legal access. Acknowledged. Done. Congrats, you got it. What does that even mean? You say things like that because when you don't get your way, and you did this to Kranek a lot too, oh, you didn't acknowledge my pro se status or that I have limitations because you didn't align with me. You didn't give me what I wanted. As if she did have legal services and all the equal things, she would have been agreed with, which the answer is still no. You still would have lost your criminal case. You still will lose your civil case, regardless whether you have one lawyer or three blind mice trying to lead a ghost ship into Bermuda Triangle. It was a mess, and it's always going to be a mess. And it's funny, 2 and 4 are separated, but they're the same thing. Acknowledge her pro se status, recognize her continued efforts for retaining legal action. You should have just had that as one sentence. You shouldn't have it at all, but if you're going to have it. And then recognize her role as the child's primary caregiver. She doesn't know that. You're just saying words. You have no proof to show that you were actually the child's primary caregiver prior to your incarceration. Why? Because all the evidence shows, and you even agree, that Brian has to blow up your phone just to see if you're going to get your son. And you get annoyed that he blows up your phone, even though you know it is just for him to check to make sure and see if you are going to be the parent you are supposed to be.
Because I was supposed to have my son today and pick him up from school. Brian usually calls to make sure, hey, are you sure you're getting leave today? Because I've had job interviews.
11:30 is when I started calling to find out, because this is supposed to be her day. Child.
Okay.
She's generally not very good about always doing it. She tends to drink.
They called back and said she was still there, or she came back.
So I was calling to find out if she was going to be getting him or not today.
Well, it was going to be Monday. I had him on Sunday and dropped him off at school, and I was calling to try to find out if she was going to be actually picking him up that day.
Why would you have a question about whether or not she was picking him up?
She wasn't generally very good about actually getting him on the day she was supposed to.
So it was not uncommon for you to have to remind her to pick him up, or to make sure that she was going to pick him up?
Well, I mean, remind or just find out if she was going to, or if she was just going to give him over to me as what happened.
Are you going to pick up? So after he called, like, maybe 3, 4 times, maybe 5, I finally answered, and that's like...
Do you think you were sleeping and missed those calls?
No, I ignored them.
You ignored them?
Because he's notorious for blowing up my phone.
Okay.
Things you described, your ex-husband, Brian Boone, notorious for doing things like nagging and calling all the time. You would not answer Brian Boone, your ex-husband's phone calls, just so that you could let him know that you're busy and you have things going on, correct?
I knew that at whatever time it was that he was calling me, that he could wait for the few moments of me getting up to where out of school at 3 o'clock.
Okay. But you wouldn't return his call. You would let him call several times, correct?
That day, yes.
Okay. How about other days? Would he have to call to remind you to get on other days?
He wasn't reminding me, he was just...
But I understand why, because he's making sure that he gets home.
Making sure that was covered for a pickup or drop off.
My phone ringing, and I knew it was Brian, because he called over and over and over and over again, which is what he does.
You assumed it was Brian?
Yes, because he calls back to back to back to back to back to back.
So I actually didn't have final answer. Okay.
What would you say people would say you're notorious for?
That's the thing too, but you can clearly tell. You can clearly tell that I had been drinking some. You can clearly tell.
I had several people that came up to me in that apartment complex said that you were drunk on a daily basis. And
Oh
you were
my
screaming
gosh.
at him
Right.
regularly.
Right.
They almost always seem either like tired or like tweaked out.
Tweaked out?
Yeah.
Would Sarah always be intoxicated when you saw her?
Most of the time.
Did they both drink a lot?
Yes,
Yes. Okay.
in excess.
What?
In excess. They didn't drink to drink. They drank to sunrise to sunset, all the time in between.
The way they presented themselves, you know, they were always drunk, like I was saying before, like always, like sun up to sundown type thing.
Really?
Right. Talk to the property manager. Talk to the property manager.
Okay.
I do know that I have seen both of them intoxicated as early as 9 o'clock in the morning, and I mean staggering, falling down intoxicated. Both of them. 9, 10 o'clock in the morning, they are drunk, falling down, cutting up. Her nickname's Drunky the Bear. I mean...
Because it's not...
These are your neighbors, the one that live next to you. Your property manager does not live next to you.
Are they going to tell me that you're an alcoholic?
They'll say that, but they don't know. They assume.
Okay.
What would you say people would say you're notorious for?
So we will recognize his efforts to make you a caregiver to your child prior to your incarceration, but not really your non-existent efforts. Approve mediation for alimony. Nope, had your chance. Blew it. Done. Too much money has been wasted, and we're not doing this back and forth. Because if they did do the mediation, that means they still have to play on this merry-go-round. But once they just push through and get the court to completely sever alimony and your parental rights, they don't have to deal with you ever again. And you can't just get things canceled, mediation canceled like that without any proof. If the judge approved it and you were supposed to set a schedule and then the lawyer goes back to him and say she didn't want to do it, they're not just going to go based off of the word of the attorney. They need the proof. And the attorney says, here's this long-ass letter I got from her just demanding the world. And the judge looked at that and said, okay, you're right. We're going to cancel that and you're just going to go to trial. And the fact that trial is only projected to last 2 hours. They are projecting a 2-hour max trial. They could probably finish this in 30 minutes. I mean, if her jury and her criminal case could wrap this up in an hour and a half, I think this case can be wrapped up in an hour and a half too. Provide the information about your personal property? Nope. And grant any further relief the court deems just and proper. And I think that relief will go to Brian and your son. And truly, she's still going to get away with not fulfilling her financial obligation. She wants to say, I'm part of your budget. You have an obligation to take care of me, to give me this, give me that. Meanwhile, you haven't done anything for your son still to this day. And they just want you out of their life. They're not trying to collect money from you. They could. They could terminate parental rights and try to get you for all the back child support. You don't have the ability to pay, but that's going to be a you issue to figure that out. But no, they just want you to leave them alone. So I do have the order from the case management hearing after all these motions were submitted, along with other ones that I'm not going to go through because who has time for that? I don't know what happened with my mic. I think it connected to my headphones. So the audio is going to be whack for this next part, but it'll be fine. We're too far in. I'm not redoing it.
Order after case management conference on March 26, 2025. This cause, having come on March 26, 2025, for consideration during a case management conference, the parties have appeared in the court having reviewed the court file and being duly advised in the premises, finds and orders as follows. 1. The parties appeared for a virtual case management conference. 2. Petitioner advised that he is ready for a trial final hearing. 3. The court noted that there were pending motions that needed to be heard prior to trial as follows. Motion for court orders. 2, to obtain and present evidence for pro se respondent to provide court, filed 3/5/24. Motion to review, filed 3/20. Motion to withdraw, 3/20, 3/23. Motion to be heard during case management conference on Wednesday, March 26, 2025, and requested relief to be ordered by court from Brian C. Boone to pro se respondent Sarah K. Boone, per FLRP, and amended motion to be heard during case management conference on Wednesday, March 26, 2025, and requested relief to be ordered by court from Brian C. Boone to pro se respondent Sarah K. Boone, per FL. 4, respondent made an or tennis motion for mediation, to which petitioner objected and the court denied.
And there it is again. After asking a million times, she made an or tennis motion at the hearing. Or tennis means oral motion of, can we please have a mediation? I know y'all keep saying no after I was the most difficult person imaginable. Can we please have it? Brian objected again and the judge denied it. This is going to trial. You cannot back out of this. You will lose everything and then blame everyone again. But always know that for every situation that we've seen in the public eye, you could have had a different outcome had you behaved yourself.
4, again, the court ordered to exchange of update mandatory disclosures within 30 days of March 26, 2025. 5, the parties are further ordered to file the certificates of compliance with updated mandatory disclosures by Monday, May 5th, 2025. 4, again, a 45-minute pretrial conference was coordinated for May 29th, 2025, so that the motions listed above could be heard prior to trial. The court will issue a pretrial conference order, done and ordered at Orange County, Florida, on this 28th day of April, 2025, LaShonda K. Jackson.
And that was her ruling. That was that. I don't understand about the awkward numbering. I think people just copy and paste old language from different and past motions, and she just didn't care. Or there's a typo and she just said, get this out of here. This case didn't mean anything to me. But another short, simple ruling. And I know it's going to drive Sarah insane because it's not as in-depth. It doesn't address everything she wants to address, which they're going to do at this May 29th hearing. So all of this stuff that was brought up, they're going to get into it a little more, make arguments, and then I think more formal decisions will be made on that big list of motions. But in general, doesn't look like it's going to go in her favor, especially after you make the oral motion to have mediation and she says, no, thank you. But all in all, the case is heading in the exact direction we all thought it would be, with it looking in favor of Brian's side. So hopefully very soon, within the next few months, Brian will be released from the chain of Sarah Catherine Boone Paulsen.
Eating my peach.
And can finally start to rebuild his life with his son without the fear of constant harassment. Which, I mean, she's still going to message you just as much, still going to harass you just as much, but you just have absolutely no obligation whatsoever to respond or even read them. I think this is where I'm going to wrap it up. I don't really have any other concluding thoughts because I've been talking for nearly 4 hours. I will say that this video, more than almost any other video I've made, I've had the biggest creator's block I've ever experienced. I don't know what happened. It was just very, very difficult. I meant to have this out weeks ago, or at least a week ago, and yeah, recovering from issues, but also I just couldn't sit down and get it done. And I think that is an indicator that I am burned out with Miss Sarah Catherine Boone Paulsen. She is exhausting. I'm still going to be making content and videos because there's still things I have to check off my list that I haven't covered yet. But I might need to transition to something else for a little bit until I can recharge and then revisit this disaster, but much like Brian and his son, she's driving me crazy. So stay on the lookout for the next video, which will be officially tackling a new case for this channel that I haven't talked about yet. You all know what's coming, but if you don't know what's coming, stay tuned. But if you like this video, make sure to like, comment, subscribe, dislike if you're feeling it. Until next time.